Order was challenged before the Honorable Court by filing a review application. So, Lordship may have made some mention.
Lordship seeking
Good.
leave to file this matter and move it urgently before your Lordship. This is a very fine matter, my Lord.
And what is the urgency?
The urgency is that the petitioner is a specially able person, and petitioner's brother is a specially able person. A caregiver was given to him for his caretaking and all. Now that caretaker with some other associate had fraud him by selling his property and selling his property to somebody else and taking all the money. Milord, there is a huge fraud. No investigation is going on. Milord, we are seeking for transfer of the investigation to anti-cheating and fraud detective department, Lal Bazar, Milord.
When the FIR was registered?
Milord, the FIR was registered in the month of May, Milord.
In the month of May. Transfer of investigation, it requires, please mention before the file it, please mention before.
There is another thing. In the month of February, since the month of February, we were trying that so that the FIR after 156.3 the FIR was.
Right, so now nothing will happen within 2 days.
No bank accounts has been.
No,
I beg to mention one
no urgency, you can file it.
I beg to mention the correction, my lord. One civil revision 3538 of 25. The order was passed where in the last paragraph the direction was cast upon the learned ADJ, whereas the direction should have been on the learned civil judge junior.
Correction. Please hand over the slip.
Lordship may be permitted to mention for inclusion in the list of a review petition, and that the matter was been disposed of. The CO has been disposed on August 28th, and the next date in court below is on 19th.
Please hand over the slip.
Lordship,
Another review application. One review application, another review application. Lordship, this order was passed by your Lordship and the Honorable Chief Justice T.S. Shivganam, and the order was challenges before this court by.
I cannot hear it. So you have to.
Honorable Chief Justice, now the Honorable Chief Justice, Acting Chief Justice was assigned this matter by your Lordship and Honorable Justice.
Assigned?
Yes, Lordship.
Hand over the slip.
My lord, may I permit? I am praying for a leave, my lord. There is a my lord, second SLST result. Merit list is declared in 15th November, my lord. They manipulate in the list, and that's the reason the applicants are want to place a sit-in demonstration, my lord. That's the reason I am praying for leave, my lord.
Sit-in demonstration. When do you propose to make that demonstration? What is the date?
Matlab 19th. 19th November to my lord. 18th.
Today, sir.
Yes, my lord, today. I am praying for any day, my lord, from today, my lord.
File it, it will appear. Yes.
I am praying for leave.
My lord,
Leave to file.
My lord, my number is 20223-2024. My lord, hard on 12/11/2025.
Yes.
That is fixed that matter. Today, under heading 4 orders. But my matter
Not appearing.
No.
But
2005.
May I hand over the sleep? I was a little late. The sleep it's a group one motion.
Mushal, please hand over the slip.
My lord, may I be permitted to mention a matter for extension of interim order?
Hand over the slip.
Lordship, mentioning another matter, Lordship.
Yes.
9 matter. My lord, in this matter, Lordship, the petitioner was brutally injured. He was brutally being harassed by the accused person. The Honorable Justice Shubhra Ghosh has heard it extensively. My lord, the problem is that now, after the order of the to submit a report, now they are again harassing the petitioner, my lord.
You can wait, madam, for 2 days.
My
Yes.
lord, listed motion for inclusion.
Group 1.
Group 1.
Hand over the slip. Yes.
Group 1 matters heard by other bench. It was directed to appear as for orders, but it has nothing.
For orders, Mr. Vera, it has to be hard because for orders by the other bench, it has to be hard.
Let it appear in subject to lordship's convenience.
The hearing matter.
No,
Affidavits have been exchanged.
no. It was.
What is the issue?
Issue is that whether payment can be made in terms of the degree in exercise of power under Article 226. There are several.
It can be made in terms of a decree. Decree passed by Supreme
Yes,
Court.
that's the point. It was argued because there is a full bench judgment of Andhra Pradesh High Court. Here it is distinguished. If the government made unnecessary delay, took unnecessary adjournment in the executive court, in such cases, mirror this court has the power.
Who is appealing for the other side? Have you served notice?
I will serve notice, then mirror I will handing over.
Serve notice, then mention after hand.
Yes, very, very.
Yes,
I
Mr.
have already served notice. This is of court number 26.
Court number.
Record number 5, sir.
Sorry, code number 5. At the present moment, code number 5. Just the
Yes.
Honorable Justice Subhra Ghosh. My lord, your lordship sitting in 227 jurisdiction passed an order in my favor, affirming the order of the DRAT regarding police help. Now, police is deleting matters. This is not. You clarify the order. This is the. But that's why, finding no other alternative, we have filed an application. We before this honorable court under Article 226 regarding police inaction. Now, your lordship has the jurisdiction.
It's a
We are facing regularly.
you not wait for 2 days, Mr. Chatterjee. It's only the determination is only till
Up to
Monday.
Friday, 3 days, but
Not 3 days. Today is Wednesday. So
only 2 days.
Friday.
Your lordship can keep it tomorrow. I have given notice to them. It's not that I am mentioning without notice.
What is the grave urgency, Mr.
The
Chatterjee? Only urgent matters. This can wait. This can be taken up by
Urgency is this. This is the urgency that we are losing our financial interest regularly.
Please move before the regular bench.
Because the order has been passed by
Only
your lordship.
exceptionally urgent, which cannot wait till Monday, Mr. Chatterjee.
And if the property is transferred to the third party, then even if I make the auction, then it will be frustrated. That's the whole trouble. That is the whole trouble. And your lordship passed the order on 4th September, not today, 3 months back. And last 3 months, we are.
I think it's better if a different judge applies its mind again on that.
I will not say anything more.
Thank you, Mr. Chatterjee. Yes, Mr. Banerjee. Yes.
No.
Oh, matter. All right, call the list.
My lord, I beg to appear for the petitioner. My lord, the private respondent was illegally filling up a pond. My lord, I took up a writ petition. I filed the writ petition. The writ petition was initially
mentioned.
Yes, the writ petition was initially dismissed on the ground of locus standi. Against that, I preferred an appeal. My lord, appellate court, the division bench has reversed the judgment and has directed, my lord, the matter to be heard again, my lord. It has to be heard on merit, my lord. Now they are filling up the pond. Your lordship would kindly take the last paragraph. It has been remanded, paragraph 21.
Yes.
And now, my lord, they are filling up the pond. Your lordship would kindly take the writ petition. My lord,
Why
there
it
is
was held that the writ is not maintainable?
Yeah, my lord, I was granted a liberty to file public interest litigation. My lord, I tell your lordship, my private respondent is my neighbor. They were filling up the pond. The pond, my lord, I have a easementary right. I have pleaded that in my writ petition that I use the pond. Now, there is a separate preemption proceeding in respect of a different plot of land. That is something else. And in so far as this pond is concerned, it has been recorded as a water body and it is being illegally filled up.
So here you are the preemptor in that preemption
In
proceeding.
that preemption proceeding.
And preemptee is the private respondent.
Private respondent.
Mr. Banerjee, what prevented you from obtaining an order of injunction in the preemption proceedings?
No, plot is different. That is separate plot.
Oh, that is not the subject matter of preemption proceedings.
Not the subject matter of the preemption.
You are appearing for?
I am for the private respondent. I am led by Mr. Mrityunjay Chatterjee. This matter has come up suddenly. I am praying for 2 days accommodation. I am praying for an accommodation, madam. Kindly, if madam, please kindly.
The state matter has been disposed of earlier, madam. That is
matter has been disposed of. It has been remanded by the
kindly directed the face copy, my lord. He is the only.
My lord, I have served them again, my lord.
They have served prior to my disposing of the matter. Now the matter is disposed of.
Once a matter is.
Then my lord would since there is extreme urgency, my lord, kindly fixes the date, my lord. There is extreme urgency because their entire construction is being going on, my lord.
Mr. Banerjee, learned advocate, Yes.
Might please, your lordship, my lord. For the petitioner, I must be candid to your lordship that my service is not complete here. My lord, this is with respect to my lord.
Private respondents are there.
No, my lord, no. State, and my lord, the railway authority would be my lord the answering respondents.
Railway authority.
My lord, here, my lord, this has been my prayer before your lordship, my lord, is that his
compensation
and my lord employment on the
Where is the
land.
award passed by the railways?
My lord, I see, my lord, that the that my lord, the if your lordship kindly turns to my lord page number 16 once the notification.
You're challenging the notification.
I did not, my lord. I say that my if your lordship kindly sees right hand side, see the dark number is mentioned as 6798. I'm sorry, my lord, it is marked.
Yes.
That dark, my lord, it is a private shali property or belongs to the petitioner. Sorry, my lord, the father of the petitioner. Petitioner in the meantime passed. Father of the petitioner in the meantime passed, my lord.
What are you submitting?
I'm sorry, my lord.
Yes.
So my lord, he made an application before the authority that as per the 2013 Act, the schedule therein, my lord, he is entitled, my lord, to an employment under the land user scheme. So, my lord, that
employment,
yes, my lord, that is there in the 2013 Act in the schedule, which is already held by this honorable court. So, I do have the book as well as the, my lord, the judgment of this honorable court.
That is the 2013 Act. And have you seen the latest decision of the Honorable Supreme Court on this? Whether you have a right to claim employment.
The
land loser.
I did not check, my lord.
Very recent judgment.
I did not check, my lord. I'll check
2013 Act to the
I only could, my lord, say your lordship that my right of getting the employment is.
Consider this because
I'll do that. I'll do that, my lord.
If there is a scheme, because
I'll do that because the 2013 Act, my lord, provides a schedule, and in the schedule, my lord, as per the resettlement scheme, my lord, there are options, my lord, 3 options.
Yes, so a scheme is to be framed for that. Act provides for framing a scheme.
Now, my lord, I tell you,
after that, has the scheme being framed?
It is a railway. The Act itself says that this will be operated on the railway property acquisition by the railway.
Did the railways frame a scheme for employment?
My lord, subject to correction, my lord, the scheme, lordship kindly sees the schedule there. It doesn't, subject to correction, it doesn't, my lord, talk about a scheme. It is straightway. If your resettlement scheme, copy.
Schedule, which schedule? Schedule 2.
2013 Act.
Schedule, first schedule, second schedule. And offer for, no. For employment. Exactly. Schedule 2, point number 4.
I better, my lord, come prepare, my lord, after, my lord, going to the Honorable Supreme Court as well and with the Act. My lord, I am sorry, my lord, I am not.
So it's or.
Yes,
It's
or.
They can frame a scheme. So it's not that you will have to be provided for an employment.
I will be given with the option that what you are going to take. Lordship kindly sees the
provided, shall ensure that they are provided with the following option.
Yes. So this exactly has been held by this honorable court, that this is a mandatory provision that the option has to be given to the persons. No.
Please consider that.
I'll consider the Honorable Supreme Court.
It took into consideration this, whether a land loser is entitled to an employment as per the scheme, whether he has the right to claim employment.
I'll go it through and come back to your lordship.
I think it was end October or early November.
Very well, grateful.
Mr. Rai, learned advocate appearing for the petitioner. Yes.
Appearing for the petition, I'm late by.
I'm appearing on behalf of the Pollution Control Board, Your Lordship.
Pollution Control Board.
Respondent number 7.
Mr. Sher, you are appearing.
State respondent.
State. Yes.
State Sanjay আছে তো? My lord, here the case is with regard to
Let's do pollution.
sand mining.
Sand mining, Your
Sand
Lordship,
mining.
consent to establish and operate were granted by us.
Oh, so
Environment
no inaction
clearance.
on your part.
No inaction on my part.
Inaction on the part of Mr. Sen's client.
State.
There is no consent to operate, no consent to establish now.
Yes, terminated.
Oh, terminated.
By
What are
pollution
you
control.
challenging? Are you challenging that consent to operate?
No.
Lord, we have suspended the license.
Yes.
Order of suspension.
স্যার আমারটা আমি শুরু করি তাহলে সুবিধা হবে।
If the order of suspension is under challenge, affidavits are to be exchanged.
My lord, what
There is
happened?
no scope to pass any interim order.
From-
Where is the order under challenge?
Your lordship kindly sees the order of suspension first.
Yes, page.
Page কতটা?
ওই কথা ঠিক আছে।
100.
Page 100.
Yes. 98, sorry.
Page 98.
This is show cause. Your lordship kindly sees the show cause first.
Yes.
Whereas on the basis of findings received from the subdivisional officer Bishnupur Bhai, its office memo number such and such, dated such and such, it appears that illegal sand mining activity were being carried out beyond the location of leasehold area. This is the show cause.
Yes. You have replied to this.
Yes, I have
Now,
replied.
what is the decision on this?
Yes. Page 100,
100.
lordship.
Page 100 is the order passed by this court.
No, page
The AD.
P8.
Oh, sorry. Page. Oh, page 100. Yes.
Yes. Whereas a show cause notice was issued to Anil Kumar, the lessee of the sand block such and such, dated such and such, on the basis of finding received by the subdivisional officer regarding illegal mining activity and carried out beyond the leasehold area, and whereas reply submitted by was found to be not conclusive and satisfactory, and whereas such illegal activity of the lease are contravention of the existing rules, norms and procedures of sand mining, now therefore
The challenge.
this was challenged in another writ petition.
Yes. What happened after that?
That writ petition was disposed of by directing the district magistrate ko to? ADM to decide with regard to revocation of the suspension order.
Where is that order?
Next page, page 102. Para 15, the operative part. In view of such, this court, while disposing the instant writ petition, directs that
Yes. What happened after this?
thereafter this order passed.
Which
The
order?
impugned order, page 108.
108.
Now, your lordship kindly sees what is the finding of non-revocation of the
to 119.
19. But only one paragraph is sufficient.
So
118.
Yes.
Moreover, in the aforesaid notice that issued by WB PCB wide notification number such and such, the petitioner lessee has been directed to stop all mining activities without obtaining consent to operate. Consent established from the state board. The respondent, representation of the petitioner and landed advocate of the petitioner are asked to show cause CTO CTE with respect to the sand ghat in question at the time of hearing, but they could not. In light of the above, until receipt of such and such, the order for suspension of mining activity issued by to the petitioner Anil Kumar could not be revoked and will remain operation. The show cause is in respect of mining beyond the area. Now rejection is on the basis of pollution.
Now, Mr. Sen, can the action travel beyond the so cause?
Yes. Started playing football, ended with cricket.
Lord, first team, Lord, it's an appealable order. The rule.
Mr. Sen,
No, Lord, I'll satisfy your lordship. I'll satisfy your lordship, but it is an appealable order under rule. They will have to go up by way of
succeed on that preliminary point.
Now,
because
Lord, please.
if the order is expressly barred by jurisdiction, because show cause was for one ground, because what's the purpose of issuing a show cause notice? To let the person against whom you are contemplating any action, to let him know on what grounds you want to proceed against him.
Lord.
So here at page 98 it says carried out beyond the location of the leasehold area. Show me the finding that you have arrived at any finding on this.
Now, Lord, please come. The order starts at 110. Now, Lord, please come to 111. Where, Lord, the district magistrate carried out an inspection.
Page 111, yes.
111,
Yes.
second paragraph. Accordingly, district magistrate Bankura filed affidavit before the tribunal, bringing on record inspection report. The inspection report discloses during field visit that there were no demarcation boundary, pillars, no machinery for extraction of sand was found at the project site, no mining activity was being carried out. Then, Lord, please turn the page over. Middle paragraph, in compliance, lessee Anil Kumar was called for hearing by the West Bengal Pollution Control Board. Then, Lord, please turn the page over. Then 113. Thereafter, inspection was conducted on 19/2/2025 by a joint team comprising of the officers are mentioned. Then, Lord, please see the extracted portion. It is observed that the boundary walls
From the extraction from the report.
Yes, the report.
To the tribunal.
Then, Lord, of the extracted portion, the last 3-4 lines, Lord, please see, the team has spotted the area of mining outside the leasehold area, and the tentative quantity of sand lifted has been calculated. The quantity of sand extracted beyond the leasehold area is such and such. So, Lord, there's a clear-cut finding of not transgressing beyond the leasehold area. Later, SDO forwarded said report to this end, with a memo dated such and such. Accordingly, district magistrate.
Pausing here for a moment, Mr. Sen, what is his reply against this show cause?
Lord,
on this point?
On this point, his reply was, I am very sorry. During the flood, my pillars must have washed away. If I have gone beyond the leasehold area, I am sorry.
Show me that.
Page 99.
Not page 99. It's a one-page reply where there is no. Your lordship will find it is essentially concession and pray for mercy. Second paragraph, Lord, last 4 lines. বানের কারণে লাস্ট 4 লাইন্স কিন্তু মহাশয় নদীতে বানের কারণে আমাদের দেওয়া খুঁটিগুলি হারিয়ে যাওয়ার কারণে ভুলবশত যদি আমি অন্য মৌজায় বালি খনন করে থাকি। Therefore, there is no defense.
So it is not a specific case that yes,
he has not done so.
Did that excavation within his leasehold area.
He doesn't say, he doesn't take the stand, no, that I did not default, I did not restrict myself to the leasehold area.
Beyond its by
I'm
mistake.
sorry, I'm sorry.
I'm sorry for that.
Please look at it with sympathy, that's all. And compensation has been calculated on the basis of sand excavated outside the leasehold area as directed by the National Green Tribunal.
Complied with?
Payment code?
None.
That has been done at the instance of the Pollution Control Board.
Control Board. I have a bunch of instructions,
Yes,
Your
sir.
Lordship.
Yes, I stopped you. Yes.
Number
Page 113, you have
Yes,
placed the
yes,
extracted
yes,
portion
Lord.
from the report.
Now, Lord, please come to Lord, page
14.
No, Lord, that the 114 Lordship will have seen because that's a reply. Then, Lord, please see last portion at 114, last 2 lines. During hearing on 19/9/2025, advocate on behalf of the petitioner stated that as there was confusion to actual periphery of leasehold area due to absence of demarcation pillars, the mining activity has been performed by the lessee beyond the leasehold area. That is absolute admission, which could not be acceptable as the lessee is duty bound by clause 2 part 7 of the lease deed to maintain and keep boundary marks in good order, the said clause is extracted. Therefore, such illegal activity of the petitioner is in clear violation of the MMDR Act and rules framed thereunder. The adverse impact of such type of illegal mining is absolutely contrary to the Sustainable Sand Mining Guideline 2016 and 2020, which has been framed.
Only one thing, Mr. Sen, 115 also there is some extracted portion. So I think this is an extracted
This is
portion
from the lease, from the mining lease, which is not annexed in the writ petition.
The lease deed shall, lessee shall
আচ্ছা,
as
তো lease
its
deed
own
টা আছে।
expense erect and at odd times maintain and repair boundary walls according to the demarcation shown in the plan. So even if it is case of that washing away of those
His
boundary pillars is accepted, then is duty bound under the lease deed to
Repair.
erect those
Make
or to
remedial
repair
action.
those pillars.
Take remedial action to ensure that it is demarcated. Because otherwise it gives a clear license to do whatever he wants.
There is no the object of giving the plan
Absolutely.
frustrated.
And there is a mining closure plan which he has to comply with. And in fact, the mining lease in terms of the lease deed comes to an end on 15th of December 2025 in just in 3 weeks' time. Because it was given in 2020, it was registered on 16th of December. It comes to an end on 15th of December this year.
That is another way.
That's a
If
matter
he is
of
entitled to, he can
even for 1 day.
Yes.
But it is not that in the impugned order, the issue taken up in the suspension notice was not considered, not gone into at depth.
According to you, the issue raised in the show cause notice was dealt with. Over and above, certain extraneous issues were.
Because Pollution Control Board had certain submissions to make this, they have been recorded and they are also clear violation. Because the Pollution Control Board comes and records before the officer that there is no CTO, no CTE. Those have not been renewed by them. Naturally, he will record it in the order.
The decision cannot travel beyond the show cause.
No.
Because
suppose during the
might be they have to be given an opportunity with regard to that also.
No, not on the issue on
Yes,
which the
on the
suspension
issue I
notice was
have shown.
there's sufficient material.
Extraneous factors, extraneous findings.
Not the impugned order can be on 5 grounds. Maybe on 5 grounds. Now, the suspension notice is on 1. If I sustain that, I don't need to take your lordship into the others. I'm not even going into the grounds taken by Pollution Control Board. I'm only going to grounds on which we had issued a suspension notice. And I'm showing your lordship, it was considered, they have made submissions, there is concession, there is no stand taken that we did not violate, we did not excavate extra sand or sand beyond our leasehold area. It's detailed order. I'm not, it is not a case that this is the appellate forum. The lordship is sitting as the Lord Constitutional Court to see whether there is violation of natural justice. He was given
because when you have shown the appellate provision, because my scope was only limited to see whether there's without jurisdiction or only with regard to that. For that, I wanted to see that whether the decision traveled beyond the issue raised in the show cause notice, because it has to be confined to that. Only for that I asked you to.
I may take your lordship further into the order. It records it.
For what?
No, on this ground. So, findings are there.
On this ground, you can proceed. You can show. Yes.
Now, your lordship will find that the Supreme Court's. If your lordship sees, then thereafter, I have placed the middle of page 115. That the illegal activity of extracting beyond the leasehold area is in violation of the statute and the rule.
Yes, what do you want? You want to avail the appellate remedy or you want to cash out here? Then after that, don't say give me a liberty. You have to take a decision at this stage.
If your lordship goes into the merits on the basis of my submissions, then it is done.
That is why it's his choice if he wants to.
Order is of September. But your lordship,
time bar
30 days.
Then I should approach the appellate authority first, then come to the court.
Mr. Sen, what do you say with the limitation?
That your lordship is constitutional court. Lordship can say that we don't.
When this writ petition was filed,
delay
19
beyond 30 days.
The order to cover.
Lordship may leave it to the authority to take a lenient view on the issue of limitation. But then statute says 30.
There are several previous judgments by the coordinate bench on this issue that the appellate authority will consider the delay and decide the appeal on its merit. There are several judgments. I appeal
Consider, sir, there is a problem. Whether the authority has the power under the statute, it has the power of extension, Mr. Chen.
I have not seen
Hey,
that.
No, no, no.
The
Power of extension
There's a statute there.
might be a problem.
There is no.
Rule 51.
If there is no power to condone, I think because leaving it will be again a problem because this issue is also pending before the
No.
Honorable Supreme Court. If the authorities do not have the power, whether it can be extended. Yes, where is the provision for appeal?
There is one.
Now, Lord,
Provision for extension?
Yes.
আছে কোথায়?
Appeal and review.
51(4).
Please check up, Mr. Chen. এই এটা দিন আগে Mr. Chen কে দিন।
51.
If
May
it
extend.
has the power, then
May extend.
There's an appeal.
there is no outer limit within which beyond
30
which the
days.
authority cannot.
No.
Then I leave it to the authorities to consider.
Lordship, may I be permitted to submit my instructions?
He's approaching the
ওকে দিয়ে দাও একটা।
না তোমাকে দিব না
আসুন
Grateful, your lordship.
Four below. I am appearing for the petitioner. I have served everybody. Here is my affidavit of service. Yes. Not a very small matter. Not the petitioner's
Small matter.
very small matter. Petitioner's property was acquired in 1988, possession taken under Act 2 of 48.
Act 2 of 48.
Then award was passed in 2002. Then, my lord, petitioner did not file any application for reference. But other landowners file application for reference in
Section 30.
28A.
Oh, sorry.
28A.
Yes.
28A. So, my lord,
28 capital A.
capital A. Now, my lord, in 2013, 2014, other landowners reference case under Section 18 was disposed of, enhancing the compensation. Relying upon the judgment within the time specified in Section 28A1, the petitioners approached the land acquisition collector for assessment of compensation on the basis of their judgment. Now, that application was not considered. We came to this court. This court directed, please consider. Now that has been considered in 2000. Yes, it has been allowed. But
allowed, then
the payment is not been made since 2023. Kindly come to page 15 for a moment.
I thought that it was rejected.
No. 2006, kindly page 15, order was passed on 16th of 2023. Has your lordship got it? This is the order. I am not reading the entire order. Kindly now come to page 20. Kindly come to page 20. The petition filed by a petition under section 28 of the land acquisition Act is allowed. Decretal amount in decretal estimate in terms of order passed by the land acquisition judge Barasat in LRA case number such, providing similar relief to the instead be calculated and sent to the department for vetting. Still then, Miller, it is pending October 2020, but 28-2 order, it is not executable. It's an award. So, kindly fix the date to
in
make
respect
payment.
of the merit, my lord, I have nothing to say.
Only
But
fix
one
the time
thing is
to
there. Well, my learned friend has approached section 28A after the expiry of the act.
This is the order.
No order, my lord.
Your order you cannot challenge.
My lord,
Your order you cannot
No,
challenge.
my lord, my order, my lord, I cannot.
Forget about.
Cannot challenge. So now,
No.
how soon you will
No.
Possibly,
My lord, I am not.
just a minute. Miss the provision 24(1)(2), 24(1) subsection 2. Here, if the land acquisition is completed, everything shall be concluded there. 24A 2013. This must be taken note of. 24(1) subsection 2. What is the, after repealing everything, we will continue under the land acquisition.
Award under section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act as if the said act has not been repealed.
Yes.
24(1)(b).
That is there. Repeal has no effect.
Yes, Mr. Mahato.
My lord.
How much time? Not my lord. How much time?
By instruction, single
from 2023.
Yes, my lord.
So,
Your lordship will minimum 6 months. As because, my lord, this is not the only court. Today, my lord, fixed. Perhaps 6 feet.
all right, Mr. De, I am concerned. This is the first matter. So,
No,
please pay.
We are also standing.
Other matters, similar applications are there. I coming to that, but this is the first matter.
Then,
as there are so many persons who have attained 85 years of age, 95 years of age. Other petitioners are there in the other.
Interest you will be entitled to.
So, your lordships will direct to pay within certain time, calculating interest up to the date of payment.
Well, that is the order is there.
Order is there, only allowed.
No.
The longer the time, Mr. Mahato, the longer the time, the more will be the interest.
The decretal estimate in terms of the order passed by the learned land acquisition judge Barasat LR such and such, providing similar relief to the instant petitioner.
Yes, now, Mr. Mahato, from October 2023 till now, for this delay, the court can impose interest, further interest. If you take much more time, you will have to pay more interest. That is why, please take a reasonable stand, a reasonable time. within how much you will, because the earlier you pay, it will be
3 months.
My lord, because calculate the money and other things, my lord, and waited after that, my lord, waited was. My lord,
waiting, Mr. Those have to be done. So don't take the plea of waiting, because this order was passed by your collector in October 2023. So more than 2 years have passed.
my lord, calculation and other things, everything has not come.
Estimate, if you want, you can do it within 1 week, Mr. Dey, I am telling you. Estimate, calculation is nothing. It's only paperwork. Calculation is only paperwork. All right, do one thing. Bring the estimate in the next week. I will see how much, when you will pay, I will give you a further time. Give the estimate. That's paperwork. That's only the paperwork. Give the calculation. The petitioners will know how much they will get. Please furnish the estimate. Estimate, Mr. Mahato, that can be.
I am making.
Otherwise, everything after 6 months, you will say that estimate sometime is.
I am.
All right. So next week, file a report in the form of an affidavit disclosing the estimate.
2 weeks.
Disclosing the estimate.
2 weeks.
That is 2 weeks, Mr. Mahato. Paperwork.
2 weeks, my lord. Now, my lord.
What now?
4th December.
No. Then after
Let
4th
it be done
December,
within 2 months, I am not
2
okay.
weeks.
what 2 months?
The payment with interest.
Mr. Bera, let them first come with the
Yes,
estimate.
very well. Let them come with the estimate.
Let them first come with the estimate. Otherwise, after 2 months, they will be saying, for SIR, we could not make estimate.
No, that cannot be.
My lord, only money.
2 years have elapsed. Till now, you are at the same stage as on the date of passing of the order. This order directed the departmental estimate to be furnished. Now, till now, you are taking, I've said 1 week, you have said 2 weeks. I'm allowing 2 weeks, but produce the estimate.
Yes.
The I was passing only to protect you. You do not
My lord,
want that, all right?
This is land acquisition collector, my lord.
Yes, third respondent.
Third respondent. So, third respondent, my lord, his report he cannot deny. He cannot deny.
Land acquisition collector, third
Land acquisition, third respondent.
Yes, yes. No,
Please check up.
yes, yes, I have to. Land acquisition, third respondent.
Yes.
The only thing you are except 5, 6, 7, 8, 9, same order.
Returnable,
On only thing.
under the heading for us করে দিন।
Except 5, mirror 6, 7, 8, and 9, same order can be passed.
6, 7, 8, 9, same.
Same. All same order, same
6,
date.
7, 8,
everything
9,
same.
শুধু date গুলো, date is also same.
All same. All same. Same date, all order same.
So please give your respective appearances.
Yes, because I am
And the respondent number is also 3.
all same. Everything is
6, 7, 8, 9, same order.
same order.
As
They are
4.
filing the affidavit of service.
Advocate, my lord, change.
Please give your appearances mentioning the item numbers.
Kept on record for it.
Just call item number 5.
My lord, I'm appearing for the state regarding item number 5.
Yes, yes. Who is appearing for the petitioner?
সব দিয়ে দাও।
Yes.
সৌমিত্র আছো এখানে ঢুকছে
আপনি না বললে কি করে আপনার জন্যই তো আমরা
The price, my lord, kindly take some, my lord, page number 7 of the affidavit of service, my lord. Page number 7 of the affidavit of service, my lord.
What
The
happened?
Private respondent, my lord, they were contacted by the authorities, my lord, to, my lord, for service of the, my lord, the notice, my lord, apparently they refused. Page 7 of the affidavit of service.
Yes,
my
who
lord.
are you appearing for?
I am asking for the state. Mr.
State. All right.
My lord, my junior is there with the report
Sir, ki private respondent?
and instruction. Kindly, my lord, allow me to submit the report and instruction.
Yes, yes.
My lord.
Yes.
My lord, illegal construction made at behest of the private respondent on the PWD road. My lord, blocking my ingress and egress, my lord. I, my lord, made
What
out
is your
the
plot?
made a. My lord, kindly take some, my lord, paragraph number 2, my lord. My lord, description of my plot of land is there, my lord.
Plot number 2.
2, my lord.
No, sorry. Paragraph number 2.
Paragraph number 2. My lord, page number 17, I have also, my lord, annexed the record of rights.
The petitioner, Ashok, disposed of. If his service taken on record. Yes, next.
Indulgence, my lord.
Yes.
My lord, one indulgence, my lord, regarding item number 5, my lord. That is the demarcation which has already been agitated. If you kindly see the report through my junior, will hand over the report that my lord BLRO has been asked, requested by assistant PWD to
demarcation made.
Demarcate the land. And the basis of the police demarcated the land, but demarcation was not made. And secondly, my lord, on the police report, basically it has been evident from the police report that it's a long ago that construction was made out. And PWD, there 100 families are staying.
But the learned
Petitioners come up with
Yes, next.
10
এই
না
রিপোর্টটা
তো আমরা দাঁড়িয়ে 10 আগেরটার অর্ডার দিলেন
10 তো হলো
Yes,
10
yes.
yes I'm
Number
statement
10 I'm for the petition.
I'm
এটা
statement
কপিটা রেখে দিন আগেরটাতে তা আগে who is for the year
I'm for the petitioner.
I'm a statement
Lordship,
Yes.
petitioner is the joint owner of plot number 168 part and 169 part, Mouja Ruya, not to district, not 24 Pargona.
Yes.
He was being owner of the plot of land by virtue of a sale deed 1989, registered in the year 1989, 1990. Subsequently has recorded his name before the BLRO. In the year 2001, 2021, 2022, suddenly a notice received by the petitioner that he is an unauthorized occupant in the plot of land. Challenging the said notice, petitioner filed a writ petition earlier. In the writ petition, state has filed a report. Lordship, kindly turn to page number
41
41 is the report filed in the earlier writ petition. In the said report, they have described about the plot number 169 that the requiring body is not required the plot of land anymore. But they were silent about the plot number 168 part. Despite of several requests by the Honorable Court, they had failed to file any report before the court. Subsequently, an order passed by this Honorable Court directing the Special Land Acquisition Officer to consider the claim regarding page number, Lordship. Page numbers 66, Lordship. Starting from 66, operating portion in the page 68. In the said order, Honorable Court has directed that the plot number 169 is free from all encumbrances.
No, that he had not held. It had said that page 66 report shows that the portion has been released by the requiring body and the petitioner is in-
Lordship.
Thus,
On the
this
basis of that
evidence
report, they have
which has already been released is free from encumbrance and is in absolute possession of the petitioner. Thus, no charge of encroachment shall survive against the petitioner insofar as the party is concerned, and accordingly the charge of encroachment against the petitioner, the portion of stands set aside and quashed. So 169
is free from all encumbrances. Only left 168.
Yes.
Accordingly, Lordship has directed the department to pass a reasoned
what
order.
has been done?
Lordship, thereafter, a reasoned order has been passed that is based on absolute fabricated fact, Lordship. Kindly turn to
What has been held therein?
They have rejected my claim. They have rejected my claim in regard to plot number 168. They have said there are other owner and they have paid compensation to them. But I was the recorded owner of the plot of land prior to acquisition, Lordship.
When the acquisition proceeding was
It
initiated?
is, Lordship, it is mentioned in their report.
Yes. Give me the date.
Lordship, I'm giving. Lordship, kindly turns to page number 48.
48. Yes.
Section 6 notification, 20th May 1998. Middle portion, Lordship, right side, 20th May 1998. The notification under section 6 of the 1894 Act was published. Page number 48.
What is your plot? 168.
169. Here 168.
Here is 168.
168. 168 is a big plot.
169 was free from all encumbrances.
Lordship.
So you are the owner of
Plot both, adjacent plot 168 and 169.
168. How much? What is the measurement?
1 katha. 168 pertaining to 1 katha 15
Where is
square.
the record of rights?
Record of rights, Lordship. I am coming to that. Lordship, now, Lordship, it was issued, notification issued on, as I've said, 20th May 1998. Now, Lordship, kindly turn to page number 33. My mutation certificate issued by the BLLRO.
Page
33. Lordship, at the top.
5 decimals.
5 decimal total. 168 and 169, including.
No. 168 is 5, 169 is 23.
23, yes. No, Lordship, this is the total area. I am the owner of the part portion. That is mentioned in the second.
Yes, mutation is 3 decimals.
3 decimal and 2 decimal. Total 5 decimals.
And 169 is 2 decimals.
Lordship.
And
dispute regarding this 3 decimal, 168.
The entire portion of 168 was not acquired. It's only a portion of 168 that was acquired. That's the eastern part.
Lordship.
So, how do you substantiate that your portion was acquired?
Because they have sent me notice that I am the unauthorized occupant over the plot of land. Because by virtue of the acquisition process.
There are two things. If you have unauthorized, a portion of a plot was acquired. So, upon declaration of the award, payment of compensation, that right vested upon the state. Now, if it is found that within the acquired portion you have encroached, then they can remove you. Now, the question is where you are now residing or you are carrying on business, whether that falls within the acquired, whether this falls within the acquisition map or it's outside that. It does not say that the entire property or the entire plot number 168 was acquired. Only the eastern part of plot number 168 was acquired. So, where is the decision? Please show me.
Lordship, impugned order in page number starts from page number 75 onwards.
Last part 75. Date was here.
They have alleged, I am the occupant.
Please give me.
Lordship.
What is your name?
Ram Kumar De.
Who is Dilip Sarkar?
I don't know, Lordship.
You have purchased from whom?
I have purchased the property from Lokhi Narayan Das. He also did not purchase from Dilip Sarkar. I never found his name in the Pit Dolils.
Page 77 is the relevant one.
77, 78.
Kindly
and 79.
stated. That was enclosed.
Where is the award?
Lordship, there is no award passed in favor of 116.8.
Yes, the award was passed. May not be in your favor,
Lordship,
but award was passed.
Lordship, award was passed. Lordship,
Yes.
kindly see.
So award was passed. So if there is a dispute, a wrong person was paid, you have to take the recourses.
Yes, my lord. Lordship, there are two things.
Where were you at the time when measurement was done?
No, Lordship. I have never served any notice under section 9. Lordship, kindly
Let them,
see. Lordship,
let them file affidavit. There is no scope to pass an
Lordship, no, there is a Lordship, kindly stay the
Encroachment is there, my lord.
Stay of what?
Lordship. Kindly
Stay of what?
Lordship, kindly takes up page 80.
Yes.
Last paragraph. It is therefore ordered that the encroachment by the petitioner over a acre of plot of land 160 is found affirmative. Accordingly, consequential steps shall be taken by the respondent 7.
If you have encroached, this is the finding. That has to be removed.
Yes, Lordship.
That has to be removed because if you are entitled to any compensation, that will be considered.
Lordship,
Encroachment of the acquired area, that cannot be stayed.
Kindly two things. Allow me 2 minutes.
Now you are saying that you have not received compensation. Whether you are entitled to compensation, that will be considered at the time.
They have filed the impugned report. Absolutely fabricatedly. Why? I am telling. Just only.
So there are two things. One, you can say that your property has not been acquired. Other is acquired, you are entitled to compensation.
My property has not been acquired because they have not paid any compensation within 1 year.
That's not the way. If they have not paid the compensation.
Lordship, kindly see
yes,
one thing.
Yes.
Page number 79. Fourth, fifth line.
Yes.
What has written? Property has been mutated on 16/5/2000. Page 79, 1, 2, 3, 4, 5, 6 lines. Number 6 from the top. That is absolutely false. Because at the time of acquisition, I was the recorded owner of the plot of
Show me
land.
the recorded owners.
Lordship, I'm showing. Lordship, kindly takes up to page number 33 again.
33, yes.
That is the mutation certificate. What is written over there? His or her prayer dated 22 Act 1998, mutation case number 07/1998. He or she is informed that he or she name has been mutated in respect of the land of declaration. When it is passed in the 22nd January 1998, and when the declaration of section 6 passed, that is passed on.
No, 22nd of January 1998 was your application, date of application. Mutation done in 2000. What are you saying?
Yes.
Mutation done on 16th of May 2000. This is seal is there. The date has been mentioned there. What are you saying?
Yes, madam. Obliged, madam.
Page 40. Lord, I want.
Lord, in item 11, I appear for the state.
Who's zero?
Lord,
I'm for the respondent number 6, Lordship.
Lord, my father, Lord, number 1, Pata
Yes,
holder.
sir.
The settlement of parties and
Yes,
actually,
sir. Patta is granted under what provision of law?
Lord, 1955. 1955.
Section? Land Reform Secretary.
Respondent number 6.
Please kindly come to chapter 6, section 49. You have a copy? No. Section 49, এটা দিন, বইটা দিন। Authority. So if there is an inaction on the part of the authority under the specified act,
No, now, Lord, what is happening, Lord? The private respondent, Lord, regularly, Lord, by using spade, Lord, cutting the mark from the,
sir,
Lord.
your prayer is for demarcation.
Yes, Lord, now,
In the representation, you have prayed for demarcation.
I mean, Lord.
So if you want demarcation,
Lord, section 49. At your lawsuit, Lord, Lord, your lawsuit, liberty, Lord, I can make a party.
what do you want? Because you have wanted the demarcation.
Yes.
Demarcation of that. Where is the
He has
private
asked
respondent?
for consideration of his representation. Your Lord, you kindly see page 9 and 10. And my Lord,
Where is the private respondent?
I am for the private respondent.
Lord, page
Yes.
his allegation is against private respondent.
on 13th August.
What he is doing? What he is doing?
Paragraph 4 below. Regularly, Lord, he cut the mark from my plot of land by using spade regularly. I made a
By using?
by using spade, Lord, for that.
Where is the land dispute here?
And
He is cutting mud and
regularly, Lord, regularly using this way and Lord, alter the mark from my field. And Lord,
where is the inaction on the part of the authorities, sir?
Lord, in the my application, can you see, Lord?
How can a writ be issued?
Can you see, Lord?
Writ of mandamus?
No, I approached before the authority, Lord,
For what?
for consider my grievance and Lord,
What they will consider?
for protection the government land or the patta land which has given to me, Lord. For such reason, Lord, the page, can you see my page 31. Page 31, Lord. The Director of Land Records and Survey, Lord, and Joint Land Reforms Commissioner issued a letter to the District Land Reforms Officer. That is, Lord, prayer for protection of patta land submitted by the petitioner.
Yes, what is your report?
Report.
Not from the police.
Yes.
I'm saying not from the police.
Yeah, exactly. Blood,
Don't show the report of the police.
Yes. Blood, it is civil in nature. Blood, I could not obtain Blood, the report from the BLR. As yet. Blood,
you have a duty to protect the land which you are distributing to the patta holders. What steps have you taken?
And the revenue inspector on Amin was visited the spot for demarcation on 13th August.
When can you take instructions?
One week, I will be able to obtain. Within 1 week, I will be able to obtain it. Huh? My junior is saying 2 weeks.
Why?
I am
Instruction for 2 weeks.
No, I am asking 1 week.
Sir, speak in the terms of days, not weeks. Tuesday. Today we are on Wednesday. I'm keeping it on Tuesday. Ashun. Number 12. 12, yes.
The land of the petitioner is claimed without any acquisition. I came before this honorable court and draw an order.
Without any,
Acquisition or requisition.
the land has been utilized. You have purchased after acquisition, Mr. Rai. Yes.
I turn to page 21.
Yes.
This is the initial order passed by this honorable court. Now you turn to page 22. Third paragraph.
Consider and dispose of the representation dated 2nd of August 2021. What has been done after that?
After that, Madam, can you turn to page 24. 5.
25, yes.
At the time of emergency situation, Madam, it is the last paragraph I am reading. Allowed the government, embankment, writ petition allowed the government to utilize the writ of plot of land willingly and voluntarily for construction embankment of on war footing measures to arrest the ingress of saline water to the save the other belongings, properties of the petitioner and also belonging to properties of villagers, countryside and constructed embankment. Since actual land utilized by the department where sheet of embankment exists with the acquisition of land due to urgency of work and with willingness accordingly. In the matter to compensate the petitioner for plot of land and land has already been utilized by the department, the process of direct purchase would be initiated according to the prevailing law of land and extent notification of the government. Whatsoever no claim will be entertained for the plot which is present in the bed of the river or part of the land which is not utilized by the government.
Yes.
Now, why not direct purchase policy? It is a purchase policy of the government. It is on the consensus basis. What is the stat? There is no statutory report. So direct.
You are not willing.
Why I am not? I'm on page 27.
Yes.
This is the first notice issued in compliance to the direction of the Honorable High Court. Malad got it. For making payment of land utilized by the
No, Mr. Rai, only one thing. Whether your entire plot was utilized or a portion of that. That is that finding.
That was considered by lot and it was
Where? Show me that.
page
Which
34.
page 34?
34 উল্টো করে তো সব
Huh?
আমার উল্টো করে
No, this is the valuation.
Decimal of variety land complying the order such and such. Gorori Bondo.
So what is the extent of your plot? You are the owner of how much portion?
This is the entire. So what this plot?
160 decibels. So entire land was utilized.
Yes, according to them, it is not my case. Apart from that, the land which has been under the river bed, I am on the allegation. This is the they did not disclose the amount which they are going to pay.
They have not?
Disclosed.
No, they have disclosed. This is
No,
the calculation.
Manar Kali Council, that is precisely what I am coming. This is later dated 13th August 2024. When I will find
This is the later dated.
13th August 2020.
2024.
But
And this
which page?
P7, the initial.
Oh, P7. 7 page. 13th of August.
Yes, page.
Yes.
This is a letter
We
written.
were asked to produce some documents.
Consent letter for purchase of land and the proposed such and such. When I got it. The compliance was sought for.
In compliance of the direction for making payment of land utilized by the, yes. What is your submission?
My submission is I have
You are asked to produce these documents.
for the deposit of the money. For depositing the money. Bank
Yes.
account number and other.
Payment of land,
Yes.
payment for land utilized.
I turn to page 35. The amount which they have ascertained and my amount is from the ADSR office.
Oh,
Market value.
oh, so you are disputing the market value.
If they are not willing to direct purchase, there is no other option to go for the under 2030 Act.
So where is the land value? According to these What according to
35,
you?
page 35, market value, set for is 1,200. My lord will not go.
Set forth is nothing.
27 lakhs, 6,492.
So this is the entire for the entirety. 160 decimals.
That has been mentioned.
No, this is for the entirety.
Yes. Apart from that, I'm entitled to get 50%. I will their
So
memorandum.
there are several plots. All the plots owned by you.
All the petitioners, my lord.
Oh, there are many petitioners. All of them joined. How many court
No,
fees?
my lord. It is the property belongs to
Court
original.
fees for how?
Another Mundal was the original owner.
How much court fees you have paid?
Another Mundal was the how the state has taken away my land.
How much court fees you
How
have
the
paid?
state taken away my land.
How much court fees, Mr. Rai?
Eminent domain, Manan Kali, remember?
When
State-
fraud was there,
Oh,
he only to save him.
of Sanatan.
his house.
Sanatan was the original owner.
Yes.
Yes, so
The state can accept
market
the
value is 2716.
Yes.
And what is the value they have taken?
They have said 10 lakhs that after my lord adding 50%, this is 6 lakhs 98,000.
So according to them, value is 698, 544. It was a
উল্টো করে পাতা দিতে হয় নাকি এখন অর্ডার করছি
একটা ভুল হয়ে গেছে স্যার
ভুল নয় কি, এটা তো যাতে
Mr. Rai, where is the record of rights?
not on it. No.
What was the classification of the land when it was
and proposed to be used, that is what?
proposed to be used as Baand?
Yes.
It was Shali.
Yes, page 16. Shall
And the valuation is as per Baand or Shali?
It is their calculation.
No, I'm asking
I
you.
fill up the form as per the direction of the
No, this valuation, Mr.
page 35, your lordship 5.
Property is on road.
Yes. Just
Embankment. When
But your-
saline water was coming,
The other details is property is on road. Is it correct? Mr. Rai, this valuation is as per the proposed, not the proposed, the current classification of the plot on land.
Proposed use. From Shali to proposed use.
Shali to?
Proposed use.
No. But the valuation, Mr.
Yes,
Rai. So valuation cannot be as per the proposed. It has to be as per the classification.
No, that is why it is the government who have initiated. If the government says this is not the valuation.
Yes. I'm not. But the question is whether, because all depends upon this. And Mr. Mukherjee, what is the basis of your saying that this is the market value? As per the, where is the document? Where is the query which you have obtained?
kindly see page 32.
Yes.
For a moment, 13th August, he has been directed to certain documents. 7
Yes.
documents.
No. He has been directed to fund certain
Let him
documents.
submit the document.
No, he has submitted the documents. Now, Mr. Mukherjee, you have calculated. Please kindly come to page 34 P8. You have said value of land as per ADSR. Show me how the ADSR has arrived at that finding, valuation. Show me the basis.
Then I shall have to call for a report from the department.
Please call for a report. How, on the basis of what? What were the particulars given by you for ascertaining this valuation? That will be the circle rate. That will be the circle rate for transfer.
Direct purchase policy is there. Purchase policy, what is the
Mr. Mukherjee, this is market price. This is market price.
2013 Act.
So if you say, as on the particular date, that was the market price, it will have to be considered whether in that area, how the deeds were registered. That is to be considered. So it's market value. It's one thing, market value and the land acquisition valuation prior.
Different.
Now, direct purchase policy, you have accepted the market value. So it's the market value has to be the circle rate. Show me the basis of your taking this valuation of the ADSR at 6,98,550.
Kindly direct to the
After after 5 minutes.
Your Lordship, my lord, this is my affidavit of service.
Yes.
My lord, this petitioner happens to be a resident of Gopalnagar, Shahilipara, my lord, under the jurisdiction of the police station Gopalnagar. My lord, this petitioner, along with all the local residents since a decade, my lord, has been organizing a Islamic Jalsa. There was never any problem, my lord, with all the formalities. Now, my lord, on 24th last year, 2024, my lord, no permission was granted, my lord. So this petitioner had come before this honorable court. My lord, I will straight away draw your lordship's attention, my lord, where a coordinate bench of this honorable court was pleased to pass an order. That your lordship will find, my lord. 17. Kindly comes to page 17, my lord, once.
Page 17, yes.
Yes, my lord. Yes, annexure P1, my lord. Page 17.
Yes.
Now, your lordship, I will
Where you are going to
my lord, this is in Gopalnagar Horipada Institution. It's a Madan, open Madan, where the headmaster, being the private respondent, has given.
There is no boundary wall.
No boundary wall. But it's open. Now, my lord, I beseech your lordship to kindly take that page 19 once. Now, my lord, in the similar fashion, perhaps my learned friend will agree with me, my lord, that book fair is being conducted also, where people are gathering, and there is no problem. That your lordship will find at page 19.
Yes.
Now,
That was conducted in 2024.
yes, my lord, thousands of people have gathered, and my lordship, my lord, had the program was also successful. Now, my lord, again we make representations that your lordship.
Where is your prayer for permission?
My lord, kindly page 20, your lordship comes, my lord.
20.
20 at 21, 22. It ends at page 23. All representations which now, my lord, they are denying once again.
When this will be held?
30th of November, my lord, 2025.
Yes.
No schedule is there, your lordship. Kindly sees page number 20 and 21.
What schedule you want?
Nothing.
The date is
Kindly,
given. The time has also been given. What do you want more?
We are not standing in the way, your lordship. Kindly sees the third paragraph of my report, sir, lordship. During inquiry in presence of the said Jalsha committee members. Examination is there, your lordship. Kindly assess once the difficulty of the police personnel.
I tell your lordship, my lord, I recollect, my lord, once I was doing a matter, as is lord, my lord, in a single bench of Justice Devanshu Bosha. But I still remember Mr. Mahato had appeared for the state, and what this point was taken, my lord. What I humbly submit, my lord, I also do consider. My lord, so far as the microphone,
if it is held to that particular
my lord, may I? My lord, so far as, my lord, the microphone, my lord, your lordship knows, as per the Supreme Court, my lord, there are certain decimals which, in that regard, my lord, I bow down to your lordship, my lord, we will not use the microphone.
There is one thing, gathering just adjacent
My lord, kindly
examination hall. Can you not
postpone the date?
Postpone the date to 1 or 2 days.
I don't know
on
when
that
the examination,
because the candidates will go at that point of time. Nobody knows what will happen. Because the examination that you have to consider. Please,
but may I, if this would have been the problem, but the school authority, but with deepest respect, the headmaster gives.
May not be the school authority. Please consider the interest of the examinees also. They are sitting for an examination. So please consider if you can postpone.
May I come back with a date so that your lordship, my lord, can pass a
date and alternate location.
What is my lord?
No, if the date is changed,
yes.
Why alternate location? That location.
Then it's fine, your lordship.
Or if you want to do it on that date, a different location where that examination center is not there.
Which one?
Two possible options.
That also, your lordship. One.
Consider If you say no, that date is to be strictly adhered to, then we have to consider a different location because just adjacent to an examination hall.
But I do respect, my lord, what is coming from your lordship. My lord, giving education is very
Only
important.
by saying that he will not use microphones, a huge gathering of 600 people.
My lord, it is Sunday. That have been
Examination is there.
No, my lord, 30th November, there is no exam.
Yes,
It is there. This
that's
is what
the
I have in my
instruction.
report.
If you are disputing that, say so, then they have
My lord,
stated on in the
both are important. My lord, I will not come on the way.
That is why.
My lord,
You can
first
choose
we
another date.
Yes.
You can choose another date or a different venue.
No, my lord, I will shift the date as per your lordship's, my lord, direction, my lord. My lord, on Sunday next, if your lordship fixes
Next Sunday, what is the date?
That will be 7th.
7th
of December.
7th of December.
Lordship, my officer has gone to take instructions. He's here. 7 December করতে চাইছে।
I'm grateful. 7th of December.
But with the restriction has.
But you have instructions or you want to put
No,
it
no.
on affidavit?
No, my lord. Upon instructions, your lordship can take it from the bar, my lord. I will not.
Don't take it on your shoulder. To file an affidavit stating that you want to shift
Affidavit file
on that, please give the specific time because it cannot be from 8 a.m. to 8 p.m. So how much time you want to please be specific with regard to the time.
This is
12 hours you will be holding that jalsa.
But the word Jolsha is very attractive. Now, my lord, what happens today? If my lord, there is a recitation of Gita and Bible, my lord, I will be the. This is why you are getting so irritated.
I'm not on that. I'm asking you, will it continue for 12 hours?
Yes, my lord, because it will take time because few people from the locality and the other locality come and they, my lord, try to convince by making this spiritual speech. And it is nothing, my lord. They have seen it for last 10 years, my lord. It is nothing.
No, in the last year, it continued from
yes,
when to when?
Same
What was the time? 8 a.m. to 8 p.m.
Yes.
Madam, please, you also take instructions on the last.
Lordship, may I just take your lordship to page number 18, which is yes.
Page number 18, yes.
Kindly sees the second line, top. Earlier experience shows.
Yes.
Yes, yes.
Yes. Let me go through. That whenever Jalsa is held by the said speaker, this would be a gathering of about 5,000 people. The petitioner undertakes to hold a peaceful Jalsa strictly in accordance with law.
These conditions
all
will have to be
conditions
maintained.
should be there, and I am not coming standing in the way.
Time. This does not say with regard to any time.
Anytime.
So you also take instructions on the earlier year, previous year, what was the time? They will file an affidavit saying that they will be doing shifting it on such and such.
That can be
and
restricted by my lord. Your lordship will restrict me so far as 5,000 people are concerned.
No, that's the same conditions that will apply.
Yes, yes.
So please file an affidavit. 2 p.m.
দুটোর মধ্যে করে দিতে পারো? Well, let it be.
We are fine with it.
Can it be, my lord, if your lordship 3 p.m.
3 p.m.
So some time will be required to prepare the affidavit.
I'm fine.
So grateful, my lord.
What is the difference? So that if once he can come out with that suggestion also.
It is because
I have already
combination which can help the state as well as the people.
If you have any other objection, your objection, one of the objection was with regard to the examination. He has conceded to that. He will be doing on that.
Grateful, deeply of that. Chalo.
Next.
তাড়াতাড়ি করো এটা করে সই করো.
Grateful, your lordship.
Thank you. Yes.
Lord, I'm being led by Mr. Orko Prabhu Shen in this matter, my lord. I'm being led by Mr. Orko Prabhu Shen in this matter, my lord. He's before courtroom number 1 in a time fixed matter, my lord. He has requested me if it could kindly be fixed at 2, my lord, subject to your lordship's convenience, because it cannot be passed over for the day. It's extremely urgent, my lord. So some preference might be given, my lord. I'll be bowing down in grateful to your lordship.
Yes. Next.
No, I'm for the petitioner. This is my affidavit of service. Okay.
Yes.
My lord, kindly take up my application which I have filed. My lord, page 10. So this is the order passed by the coordinate bench.
Item number
15, 15, my lord.
15. এটা কি দিলেন? ও শুভম Yes, yes.
Yes, my lord, page 10, my lord, kindly see.
Page 10, yes.
My lord, my grievance was in the writ petition was that this petitioner was tagged in several cases where the offenses are mostly 7 years and less than 7 years. My lord, he has been tagged after getting bail when he is going to the police station to cooperate with the investigating agency. At that point of time, in connection with another police station case, he has been tagged and arrested without serving any notice as per the directives of Anish Kumar judgment. So, my lord, this writ petition was filed. My lord, this High Court, my lord, on the coordinate bench has stated, my lord, in the third paragraph, be that as it may, if the police authorities intends to deal with
Page 10
page 10 of the application, my lord.
of the application. Can one?
Can one, my lord.
Yes.
My lord, be that as it may, if the police authorities intends to deal with the petitioner as an accused in respect of offences which are relating to prescribed punishment of 7 years or less than 7 years, in that case, a notice under section 35(3) BNSS must be first served upon the accused. Thereafter, the police authorities will proceed in accordance with law. State would submit, because I don't know, it was not in my knowledge that how many cases I have been tagged. So there was a specific direction upon the state that state would submit a report which would contain regarding the list of cases and the number of occasions on which notice under section 35(3) of BNSS or section 41A of the CRPC was served upon the petitioner. The matter was fixed for 4 orders. Then, my lord, turn to next page, page 12.
Yes.
In the monthly list of September, my lord, this was appearing under the heading for orders, item number 69. My lord, during the puja vacation, all on a sudden, police came to my residence and arrested me without serving notice, when the offense is 7 years and less. My lord, this is my principal grievance. I was taken into custody. After that, my lord, I have filed this application. My lord, the day I affirmed this application in custody, because my brother has been authorized to file this application because I was in custody. My lord, his authorization has been taken from the jail authority. Thereafter, I could file this application. My lord, the day I affirmed this application, my lord, on the strength of the old case of 2024, where I was not FIR named, it was against my brother. On the basis of production warrant without serving any notice, police was silent for 1 year. I have been tagged, I have been taken to custody. Yesterday, my lord, I have been granted bail in connection with this case, that golf green, which I have been arrested illegally. My lord, kindly see what the Supreme Court says in Ashfaq Alam's case, my lord.
But yesterday bail has been granted.
So far as the golf green case, the application I made.
Yes, so the
Now-
application relates to golf green case.
Now application relates to golf green case. The day I affirmed this application, filed this application, on that day, on the basis of production warrant, they took me to Bidhannagar. In another case, I am not related with the case. The case is related to one Sagar Jana, who happens to my brother. There is nothing in my involvement. For 2406, another case where the offense is 7 years and less. My lord, I have been tagged and I am still in custody. My lord, this kind of things, my lord, kindly see Ashfaq judgment. খোলো, আমি তোমাকে এখানে দেখিয়ে দিচ্ছি। My lord, paragraph 16 onwards, my lord, I will not trouble your lordship. My lord, kindly see the head note, second head note first, then my lord, if your lordship can please to take paragraph 16. আমি করে দিচ্ছি, এই করে দিচ্ছি। চারটি জাজমেন্টই যেটা রিপ্লাই করছি, হোয়াটসঅ্যাপ করে দিচ্ছি। অন্যান্য অনিশ কুমার এটা আশফাক খান অনিশ কুমারের বেসিসে যেটা হয়েছে ঠিক আছে 16.2 onwards, there was a specific direction upon all state governments and the sessions judges and other lower court judges. But another one is, let's kindly see. But this judgment will portray how the arrest was illegal. Kindly see. So, paragraph 12. Kindly see paragraph 12 of that judgment. This is of Bombay High Court, my lord. Paragraph 12, my lord. Another.
Yes.
Another recent, my lord, 2025 judgment.
Yes, what is the
Supreme Court judgment, my lord, where the DGP of Haryana has been personally appeared before the division bench of Supreme Court.
Yes.
Two things, Millard. So far, Millard, the list of cases are concerned, Millard, we have prepared the same and I can hand it over the same. So far, Millard, the illegal detention or the arrest are concerned, Millard. If your lordship sees the mother judgment of the Millard, the Arnesh Kumar, it provides the power. Basically, it Millard, just I draw your lordship kind attention. Millard, once the Millard, the arrest has been made, within the 24 hours, that particular person has to be produced before the magistrate. Now, magistrate has to decide whether he will be giving the reminder or Millard, he will be released on the bail. Millard, in the Arnesh Kumar case, this has to be Millard absolutely and abundantly clarified that this is the magistral power. This is not the Millard, the power of the High Court to decide the illegal detention or others, because that is coming under the Millard magistral power. So Millard, today, Arnesh Kumar Millard, paragraph 9 judgment are there.
Arnesh Kumar, no?
Please give me Arnesh Kumar.
I'm just giving.
But I am handing over the copy.
Yes.
No. Yes.
Paragraph.
First, your lordship take trouble to see paragraph 7. Have your lordship got it?
Yes, yes.
Here. As the case offences which we are concerned with the present appeal provides for a maximum punishment of the imprisonment or such and such 5 years, which is relevant for the purpose of writ as follows. When police may arrest without warrant, he is coming within the zone of that. Any police officer may, without an order from a magistrate and without warrant, arrest any person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with the imprisonment for a term which may be less than 7 years or which may be extended to 7 years with or without fine. If the following conditions are satisfied, then the police officer is satisfied that the such arrest is necessary. Millard, this particular word is very necessary. Arrest is necessary. Arnesh Kumar judgment has been passed with the flavor to avoid the unnecessary arrest. Here, Millard, the prerogative right of the Millard, the police authority has been given. If the police authority says, think he has to be arrested. Now, kindly come to paragraph 9.
Yes.
Yes. Another provision, that is section 41 is CRPC, aim to avoid unnecessary arrest. I just harping on this point. Unnecessary.
Yes.
Unnecessary arrest or threat of arrest looming large of the accused required to be vitalized. Section 41A as inserted by the section 6 of the Code of Criminal Procedure, which is relevant for the context of the writ as follows. Notice of the appearance before the police officer. The police officer shall, in all cases where the arrest of a person is not required under the provision of the subsection 1 of the section 41, which a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him. Yes. Appear before at such time, other place may be specified in the notice. Whereas this particular notice can only be issued when the police officer is satisfied that this arrest is not necessary. Here, the case is that the arrest is
According to you, it's necessary.
Necessary.
Arrest is necessary.
And
when arrest is necessary, 41A do not have any application.
Do not have any application. Kindly have a look into that once again.
সুধীন্দ্রনাথ and Bill judgment
11.6 and 11.7.
সুধীন্দ্রনাথ and Bill
Notice of the appearance in terms of the section 41A notice shall be served upon the accused within the 2 weeks from the date of the institution of the case, which may be extended of the superintendent of the police district reasonable for the record of the right. Failure to comply with the direction aforesaid shall, apart from the rendering the police authority concerned liable to the departmental action. This is, my lord, when 41 notice is required and I have violated the same. This principle will be applicable on that. If your lordship kindly take trouble to see once more the 9th once more. The aforesaid provision.
Paragraph
9.
Yes.
The lordship has seen this 1, 2, 3.
Aforesaid provision.
Aforesaid makes it clear that all cases where the arrest of a person is not required under section 41 CRPC, the police officer is required to issue the notice directing the accused person to appear before him at a specified place and time. Law obliges such a accused to appear before the police officer. It further mandates that if such accused complies with the terms and notice, he shall not be arrested unless for the reason to be recorded. The police officer is of the opinion that the arrest is necessary. At the stage also, the condition precedent of the arrest as emphasized on the section 46 has to be complied and shall be subject to the same scrutiny of the magistrate as aforesaid. So, this is the domain of the magistrate, I would say. Once the person has been arrested and to be produced before the magistrate, it is the abundant duty of the magistrate to see and pass a reasoned order that whether that arrest is necessary or not. If it is illegal, then he will be released on the bail. If it is legal, then the remand and the prayer would be given. Allowed, sorry.
But can you mechanically say in all cases that yes,
no
arrest is necessary?
No. Here, my lord, I joining the issue. I know, where your lordship is having the travel. Kindly have a look. This is the list of the cases which is pending against the person. I am handing over the case.
As on
date.
As on this date.
আচ্ছা এখানে একটা কাগজ বার করলাম one.
Now he has been roped in which case? In connection with which case?
He was.
Lastly, he has said yesterday you had.
No, my lord.
No.
On 7th, the production warrant was issued. My lord, on 10th, I was taken to custody in respect of Bidhannagar North PS case number 169.
Bidhannagar North case number
169 of 2024.
There you have obtained bail.
No, my lord.
Oh, you was
obtained bail in Golf Green.
Obtained bail in
Golf Green PS case.
No, Golf Green PS case is not here.
No, Golf
yes.
Green PS
yes, my lord. Application is filed. My application is filed citing the Golf Green PS case
yes.
where I have been arrested during
Golf
the
Green case is not here.
Possibly. Golf Green is there. I will be handing over. There is a report. আচ্ছা ওরা একসঙ্গে করে দিয়েছে আমাকে ওই ছেলেটাকে একটু ডেকে একটু বলুন গল্প কোথায় আছে
wait a minute.
Walgreen PS case, you admitted your guilt.
No, my lord.
98,205.
It's their version, my lord. It's their version. I was not FIR named. After 4 months, when 12.
I will just a moment. I will have
Yes,
please.
yes. Your
Wait,
submission
why
I will reply.
why he was arrested? That's the cracks of the matter. Although this is not the domain of your lordship, still for the purpose of satisfaction of the lordship, I'll be just handing over one privilege communications. This is relates to the Miller, the Golf Green PS. Just have your lordship seen that?
Yes.
Now, second things, this is very important. Now, lordship is sitting on the prerogative writ jurisdictions. Now, lordship knows far better than I do. In a prerogative writ, Millet Suryadev Rai was overruled. Radheshyam and Chobinath came into the picture. Now, had it been a case that it's a wrong Millet arrest or wrongful detention even, the case is being numbered in the criminal jurisdictions. In that event, 226 doesn't lie. Kindly have a look. The judgment passed by this court. Now, have your lordship sees the minute first see the head note B.
Yes.
The distinction has been made between the bill 226 and 227. Read challenging discharge in the criminal case or ground of the illegality investigation and absolutely the same availability to alternative liberty. Police officer has conducted such and such. I will be just placing Millet not maintainable. But the issue, kindly have a look into that.
Which paragraph?
Challenge, then comes the issue on the head note.
Yes, yes.
The two preliminary related issue arises from the decisions there are whether a writ petition that is directed against an order passed by a judicial magistrate in the exercise of the judicial function would be maintainable, whether in view of the remedies available for the petitioner under provision code of criminal procedure hereafter the CRPC, the writ petition should at all entertained. That is the issue. This issue has been redressed by this court.
How it has been answered? Which paragraph?
Yes, my lordship, I would see Millet skip over all the the argument. Now kindly come to the conclusion part. Paragraph 23.
23.
Yes.
Remedies under 397 CRPC invoke.
He has to go by the 482 or
Also
390.
invoke the jurisdiction of this code under 482
Yes.
or even under a constitutional provision 227.
Yes. So therefore, in the light of this judgment and the circumstances are concerned, 226, with my humble understanding, is not
27 is maintainable.
227 where I will join the issue. In a Bombay or in the Calcutta, there is a distinction. And the Bombay is 226 read with 482.
But is it this decision wherein there was a difference?
No, no, no.
Of and a division.
Radheshyam and Chabinath is the judgment, mother judgment.
Yes.
Following that, this judgment has been passed. Radheshyam and Chabinath is the mother judgment.
I'm not on that.
I understand that point where the Agarwal case, the Justice Banerjee was taking the matter. This is not that matter. It is not that matter.
Yes.
Now, in an elaborate manner, if I could place the judgment, kindly have a look to the paragraph 12 onwards.
Paragraph 12, yes.
I had the occasion to consider whether a judicial order passed by a learned district judge under the provision of the Juvenile Justice Care and Prevention Act could be subjected to a challenge in a writ petition. While deciding the same, State of West
I
Bengal,
think this is that judgment.
that judgment.
Because there are two decisions on which orders are capable of being challenged under 226 and 227. There were two conflicting views. It has been referred to a division bench. Please see this because
Is it not this Agarwal judgment has possibly referred to the large judgment?
paragraph 12 we have drawn the attention because there are two decisions on which under whether 226 or 227.
Yes.
So there was a difference of opinion, two conflicting views. I think a division bench judgment is there on this.
No, that is all right, even though if it is a
consider this because
right,
that may be one of the grounds because whether 226 or 227 will lie.
Yes, Lordship would see once again. If your Lordship kindly have a look.
Because here it says 227.
227.
Maybe maintainable because
Otherwise, yes.
Yes, other one says 226.
226 cannot be at any point of time cannot.
Please see that because there
Fine.
is also a division bench judgment.
I will go to that. But
I think the division bench judgment is presided over by Justice Ghosh at that point of time.
Justice PC Ghosh. PC Ghosh has passed that the Ernest Kumar judgment.
Oh, that is
the different issue.
Here because there was another coordinate bench which says no 226
is maintainable. Well, I will go to that. I will consider. But
and
I have prima facie. I think I have made out my case where
yes, now you wanted the list. This is the list they have furnished.
My lord.
So, where is the other list, Mr. Gupta? Where is the? You said there are other cases also.
In my list, if your Lordship kindly take trouble to see, on the second page, the golf green case has been mentioned over there.
Vidhannagar section, my lord.
Yes.
Vidhannagar PC.
Table 3, Vidhannagar case.
I've seen that inside that.
Yes.
The two cases in
on the right hand
charge
side.
sheet. Yes,
Right.
right hand side. So there are no other cases.
No, up to this, this is the case pending against him.
Yes.
My lord, may I, what was my prayer? My lord, kindly see why this coordinate bench has dealt with this matter, my lord.
In the writ petition, what we have paid for.
Yes, my lord. Kindly come to the 19 is the prayer. My lord. My lord, prayer A was a writ in the nature of mandamus commanding the concerned police authorities to act and proceed in accordance with law and to discharge their duty provided under Police Act 1861 and Police Regulations of Bengal. Prayer B was to provide to mandamus to issue direction upon the respondents number 2 and 3 to provide the details of the cases in which the petitioner has already been implicated as an accused person and to provide the reasons for this implication in this case.
This B now they are submitting this list.
As of today, my lord.
As of today, they are submitting this list.
prayer C, my lord, kindly see.
Yes.
Look, in the
Send a notice.
send
So
the-
this has to be decided.
that this has
This
to
has
be
to be
decided.
finally decided.
Yes, my lord.
And to consider, where is your representation dated 7th of March
My lord,
2025?
that is at page 67, P6.
67. That is according to you, in view of the violation of the directions of Arnesh Kumar, you have asked
yes.
the DG to take steps.
Yes.
So first there has to be a finding on that.
My lord.
So it has to be decided finally.
Yes, yes, my lord, whether since maintainability point has been raised, whether REIT will lie under say Article 226 or not, that has to be decided. So far as one of my lord
pending, I'm keeping because this is the application. So now they have given this list. I'm directing this application before the regular bench.
My
The
lord, my lord,
petition and the
my lord, kindly direct the police authority to act in accordance with law.
Has to be that has to
No,
be.
no, that has to be, my lord, that has to be specific.
All right,
Because
I'm
my lord,
recording that. I'm only recording that.
since my lord, I am not going into the all the judgments. My lord, since this honorable court, coordinate bench has given a direction that police authority should act.
Yes,
considering
that,
the
Mr.
facts.
Sengupta, you cannot violate that.
Certainly not, my lord. I have handed over to your lordship the privilege communication whereby your lordship would see, my lord, where was the scope.
No, kindly direct, my lord. They will follow the directions passed by this coordinate bench already.
23rd of April 2025.
Yes, they will follow.
The
that is binding, there is no doubt. But I would, my lord, lordship, also kindly, my lord, record my submission whereby I have indicated the arrest is the, my lord, the prerogative power of the police. They have to, my lord, lordship knows.
act in accordance with
My lord,
law.
my
If
lord,
it is
certainly,
law
certainly.
permits
It
you,
is serve everybody's purpose.
the
Judgment which I have shown of the Indrani Chakraborty
Sir,
is of
judgments
two-
will be kept on record.
Take it back, you can file it. Yes.
that is made possibly Justice Ghosh has possibly on that time passed the Annesh Kumar judgment in Supreme Court. He was not here. I will see to that. I will see. I will see.
Concepts of law, my lord, it will be decided long here.
Recollection that whether because there were two conflicting views, which orders can be challenged under
Yes.
226 and
227.
So there were a
The only thing is that Suryadev Rai after the military
Suryadev Rai is another
judicial order has been
2003 volume.
correct.
66.
Correct.
So it has been diluted to some extent in the subsequent decision.
I will see to that,
Not,
my lord.
totally over.
Bye, sir. I will go.
Been diluted to some extent. Yes, next.
My lord, this petitioner, my lord, he happens to be a senior citizen.
My lord, I am for the state color in this matter.
Now, my lord, what had happened was, my lord, for his,
The respondent number 6.
my lord, for his, my lord, job purpose, my lord, he has to stay in Pune. Now, my lord, he has a lawfully owned flat in Calcutta. My lord, I have annexed the deed. The deed will appear, my lord, at page 27. My lord, he is the owner. Lordship,
the owner?
my lord, this petitioner. Lordship would get petitioner and his wife. My lord, page 29 is the recital of that deed.
Yes, petitioner is the one owner. What
No, my
happened?
lord, my lord, what has happened is the daughter-in-law and her family members, now, my lord, they have thrown him out from the flat in question. My lord, she is
Thrown you out? Or they are
yes,
going to throw you out?
my lord, thrown out. I am not allowed to enter into the flat. Now, my lord, kindly comes to my application, my lord, before the subdivisional magistrate, my lord, which is the tribunal under the Maintenance and Welfare of Parents and Senior Citizens Act. Now, my lord, the tribunal has kept that application pending. 17th, my lord, this incident has occurred on 13th. My lord, kindly comes to my application before the subdivisional officer, annexure P8, page 112. My lord, this is dated 17th of October 2025. Now, my lord, this application, the concerned subdivisional officer, Barakpur subdivision, who is the, my lord, the president of the maintenance tribunal, my lord, no steps are being taken. And my lord, two senior citizens, they are on the road. Now, my lord, this issue, similar issue, my lord, came up before a coordinate bench in a separate manner. In which, my lord, his lordship has directed that the police authorities, pendency of the application before the maintenance tribunal, will ensure that the senior citizens are restored into their possession. Well,
What
kind,
the maintenance tribunal will decide.
well,
What
let the
maintenance tribunal will decide.
now the maintenance tribunal, my lord, they cannot be left, my lord, roaming around in the streets.
If that is an interim order, if the interim order is
No, my lord,
passed,
this is not an interim order. This is not.
what is the final order you are expecting?
No, the final order, my lord,
Will be reinstated
no,
to
no,
the
no, my lord,
company.
the final order is that the parents of, my lord, I am not worried about my daughter-in-law. My lord, their parents have no right to stay in that house. The subdivisional magistrate has a right to evict them.
Let the subdivision officer.
My lord, only the portion of eviction, but let my daughter-in-law stay in that house. I do not have any problem. But my lord, I should be allowed to enter into my own house.
Where is your application before the maintenance tribunal?
My lord, kindly comes to page 112.
112.
My lord, kindly comes to page 113. The paragraph starts with that lastly on 13th October 2025. That lastly on 13th October 2020 hours when we tried to enter into our safe flat again, the accused person assaulted and threatened us and told that if we try to enter into the house, they would lodge false cases against me and my son. So, my lord, I am only asking for the interim relief to that effect.
Matrimonial proceeding against your
Yes,
son by the
yes, by the against the son.
There is 498 and there is.
My lord, I have stated everything. There is a maintenance proceeding pending. My lord, that is, my lord, as against my son. But my lord, my daughter-in-law, my lord, cannot capture my house and my lord, drive me out from my lord, lawfully owned possession. Now, my lord, in this,
the read court do?
my lord, the read court has the right, my lord, kindly sees a judgment, my lord, passed by this. My lord, here, my lord, the police authorities kindly comes to the judgment which I have handed over to your lordships. But here also, my lord, there was a family feud between the parents-in-law and the daughter-in-law. Kindly comes to paragraph 3. Having considered the overall circumstance and the fact that there is a family feud, and the police authorities in their report have stated that they are ready and willing to render all possible arrangement and assistance if the petitioner intends to stay within the residence within the jurisdiction of Chakda police station, I direct that the petitioner would inform the inspector in Chakda police station, who would provide necessary assistance if any sort of inconvenience are faced by the petitioner and her husband while entering the residence. For a period of 30 days, every alternative day, a lady police personnel would be engaged who would visit and inquire as to whether the petitioner and or husband is facing any convenience at the behest of the respondent numbers 5 and 6. But I was praying for a similar direction, that let police ensure that, my lord, I and my wife, we can enter into our lawfully owned flat. And the deed belongs to us, my lord, every document belongs to us, and the daughter-in-law and her parents, my lord, at least her parents, as well as the daughter-in-law, my lord, they are not allowing to enter us, my lord, allowing to us to enter into our flat.
My lord, this is my.
You are for the state.
Yes, my lord.
My lord, my submission would be, my lord, if your lordship kindly come to page 112.
112, yes.
Yes, my lord, the complaint which was made before the SDO, my lord. Kindly see the permanent.
I'm not allowing your father-in-law to.
I am, my lord, ready to allow, my lord, because there is a domestic violence act has been filed under section 17. My lord, 125 has been filed, 498 has been filed. My lord, all these proceeding is going on. My lord, under the domestic violence, my lord, section 17, right to residence, the daughter-in-law has the power, my lord, to make an application. And it's, my lord, needs consideration before the magistrate, my lord. My lord, I am showing, my lord, and relying upon one judgment, kindly large judgment, my lord. If your lordship kindly come to paragraph.
But I am not saying that the daughter-in-law should not stay there. Let her stay. Let us. We should be allowed to enter.
Is Bhanita.
Yes, my lord. My lord, 22.
And whether she has a right to residence, that has to be adjudicated by the learned magistrate in that proceeding. That adjudication is not there.
Why the daughter-in-law do not have any right?
No, my lord, section 17 has to be adjudicated. Whether she has a right.
I'm directing.
No, my lord. My lord, no, my lord, my lord. Only one thing, my lord, we should be allowed to enter. Kindly. My lord, two old senior citizens, kindly.
My lord, they are permanent residences at Pune, my lord.
Now you said
I'm sorry.
When she is making a claim, you are saying that is to be decided. I'm
No,
directing
my lord.
this to be
My lord,
decided.
we should be allowed to enter because two senior citizens, my lord, kindly considers.
My lord, they are permanent residents at Pune, my lord. They are residing there, my lord. They are residing there.
They are not staying here.
No, kindly see the complaint, my lord. For this reason, my lord, kindly see page 112. My lord, second line, I, Oshit Das, permanent residence. Your lordship got it.
But for a
Maharashtra.
Yes.
For a job, we stay in Pune.
Yes. Well, in earlier
I have stated that in my
kindly
petition.
come to page 76.
But for my job, I stay in Pune, but my house is here. Kindly seize my cost.
Saying that I am roaming around.
Yes. Whenever I have to come to West Bengal, I have to come to West Bengal.
When you will come to
But we are still in West Bengal. Because I work there as a contract labor. Kindly comes to paragraph 2 of my petition once. I have stated everything.
Page 26, another complaint, my lord, there is also written.
Kindly comes to paragraph 12 of my petition. I have stated
76.
that.
Kindly see page 76.
But kindly comes to paragraph 5. I am a permanent resident of Kolkata, but on account of a job as a contractor, I and my wife and my son have to stay in Pune.
So which one is correct? The cost title you have said you are permanently residing at Shodhpur. In the representation you have said you are permanently residing in
My cost title, my deed is correct. My deed is correct. I have annexed the deed. That flat belongs to me and my wife. When it kindly comes to page 29, Oshit Das and Shumita Oshit Das.
When you have filed this writ petition?
But I have filed this writ petition on 4th of October.
You have affirmed at that point of time we were.
No, it was before
Maharashtra.
No.
Yes, that's
yes,
in the
representation
affidavit.
says so.
Please kindly come to page in the affidavit page.
My lord, he has come.
Presently, that means as on the date of affirmation, you were residing in Maharashtra. That's your statement in the affidavit.
But I have stated permanently residing
Yes,
at
but
Vijayawala.
presently you are residing at Maharashtra.
But on 24th of October, my lord, this incident happened on 13th of
The
October.
tribunal to decide this.
But kindly allow us, my lord, to at least enter into the flat.
You are residing in Maharashtra.
No, my lord, I have stated that on account of my job, I have to stay there.
Yes. Now, how many rooms are you occupying? What is the? It's a single-storied building or a double-storied
No,
building?
it is a flat.
It's a flat. So you are occupying one room. So what objection do you have if the?
But I don't have any objection.
So
If they come, my lord, I will allow.
file an affidavit that you will not object to the when?
Monday.
Monday. Where is your client?
But I shall ask him to be present in court.
Where is he now?
He is in Kolkata. But he is in Kolkata staying at a relative's house because he is not able to enter into his own flat.
The
My lord, another thing, my lord. My lord, kindly see the last page of my judgment, my lord, which I have
last page of
judgment, which I have handed over.
yes,
Paragraph 24 once.
paragraph 24. Paragraph. Yes, 24.
Yes. My lord, for the above reasons, we have come to the conclusion that the claim of the appellant that the premises considered under the shared household within the meaning of Domestic Violence Act would have to be determined by the appropriate forum. The claim cannot be simply be obviated by evicting the appellant in exercise of the summary power entrusted by the Senior Citizen Act. The second and third respondents are liberty to make subsequent application under section 10 of the said Act of 2007 for alteration and maintenance allowance such and such. My lord, then my lord kindly come to point 4, next para. My lord, in order to enable the appellant to pursue her remedies under the Domestic Violence Act 2005, there shall be an order and direction restraining the respondent from forcibly disposes of the appellant, disposing of the premises from creating any right, title, interest in favor of the third party in manner whatsoever for a period of 1 year to enable the appellant. The appellant is at liberty to move the court for the spouse her remedies under the Domestic Violence Act. We have applied already. In this proceeding, that has to be decided by law.
Yes, but you do not have any objection to allow the father, and you also cannot evict.
No, I shall not. I shall not.
Affidavit that you will not evict.
I shall not. I shall not.
Disturb the
But that is only.
as well as not create any disturbance. If any complaint is made, the police authorities will take steps then and there.
Only thing is, my lord,
By evicting you out from your own.
only in respect
If
of
any
my.
allegation is made.
I am agreeable to that. Only in respect of the daughter-in-law, but not her parents.
No, their parents are not residing.
But only in respect.
Then you proceed. I am directing the
Oh,
tribunal.
but I shall file an affidavit. I shall file an affidavit.
Eviction now at the interim stage. First of
But
all,
I shall file an
the
affidavit.
court do not have any power.
I
to
shall
pass
file an
order of
affidavit that I will not evict my daughter-in-law.
and the police authorities cannot decide the issue of possession.
I let them.
There is no inaction on the part of the police authorities which you are agitating here. So how can a writ of mandamus be issued here, Mr. Das?
But I shall file an affidavit to that effect that I will not evict my daughter-in-law.
Not disturb her possession.
Not disturb her possession.
And because she is in possession, you.
I shall not disturb
and,
her
You
possession.
also have to file an affidavit that you will allow him to re-enter the
Because of the SDO issue the demolition order against me. And
Under what provision?
Yes, Lordship.
Under what provision?
Illegal construction.
State highways.
Under which act?
PWD.
Highways Act.
Highways.
There's the provision of appeal, sir. Please apply. Yes.
Appeal has been done, Lordship.
Right,
I must
please
state, my
do-
lord.
I beg to appear on behalf of the petitioner. I'm extremely sorry. I was on my legs before the honorable division bench. My lord, I have come. It's a very sensitive matter, my lord. I've come with a very innocuous prayer, my lord. I had mentioned this matter yesterday for obtaining leave to move it today, my lord.
Yes. Yes.
But the petitioner before your lordship is a lady who is a senior citizen and also a widow. And my lord, the private respondent is my son. And my lord, the lady, my lord, property, my lord, the house belongs to the lady. My lord, I have annexed the deed. That will start from my lord, page 13 onwards. Now, my lord, the problem I am facing is that my lord, my son is staying in one store, my lord, in the first floor. I am staying at the second floor. So, my lord, I don't have any in the ground, and I am in the first floor. So, my lord, I don't have any objection, my lord, whether he is staying or my lord, no question of evicting. Now, my lord, since my lord, I cannot survive, my lord, he is not maintaining me. I have decided that my lord, the one portion of my own property, I will give it into rent, and by that rent, my lord, I will, my lord, somehow, my lord, survive in life.
Which portion you will give it on rent? The
My lord,
son's portion.
no, my lord, the remaining portion, the entire floor he is not using. Malad, the remaining portion I will give into the rent. And malad, I try before that, malad, I need to do some work in that because malad, the old house, malad, to maintain that I have to do some work. Malad, my son is not allowing me to do that. And malad, he started beating me, and each and everything is going on. Malad, then when I filed this writ petition, malad, during this period, Malad, two times this lady was assaulted by the son. Malad, these are the medical reports. Now, Malad, the coordinate bench, Malad, since the sons was not appearing, Malad, the coordinate bench asked the state to intimate the son that the writ petition is pending. Malad, state was supposed to
Lordship, in
do
the
that.
previous order, Honorable Justice Shubhra Ghosh has directed the police to intimate with the private respondent, Lordship. And today, private respondent is appearing, Lordship. And Lordship, as per my report, Lordship, long pending family dispute, Lordship, purely civil in nature, Lordship. So, daughter is supporting her mother, Lordship, as per report, Lordship. To kindly give the direction, Lordship, to go to the appropriate forum.
So now it's basically a dispute between the brother and sister.
Yes.
Now, Malad, I don't want Malad, the sofa, the
Maintainable, sir.
Malad, the eviction and all. I'm not saying that.
Our it is maintainable.
Malad,
There is the inaction on the part of the police authorities.
the police.
Show me the complaint you have lodged. I will request them to take steps in accordance with law.
Malad, that complaint is Malad, I send it to 3 Malad authority. Malad, the same complaint. Malad, page 22 is to the subdivisional officer. The same complaint to page.
Subdivisional officer.
No, Malad.
Proceedings. That,
Yes, Malad.
that will go on.
26 is the same complaint to the officer in charge.
Page.
Page 26.
Does it disclose any cognizable offense? Offense under what section? Please tell me. Which section
There is a earlier complaint that was filed on 16/5/2025. That was
which page?
Maladi, I have mentioned that in the complaint in 16/5/2025.
You have a cognizable offense. These are basically civil disputes, which are disputes before the maintenance tribunal. Next steps for
Malad, I can understand. Malad, give one thing to me. Malad, the protection to the murderer by the police to keep vigil that so far the assault part is going on, that to be stopped. Malad, I am not.
Make a complaint. If there is any assault, you will be making a complaint. If there is the complaint discloses cognizable offense, it's the duty of the police to take steps.
Malad, kindly observe that, and Malad,
the petitioner.
page,
Yes,
para 4.
let us keep that aside. Complaints. What's the dispute between you and your mother?
My lords, the sister and the mother are siding together to basically give the property for development. I have heard there have been talks and finalization.
Right in the property.
My lords, I have no rights. It's my mother's property.
Please move out from the property.
But my lords,
Get better accommodation. Move out.
absolutely, my lords, but that has to be informed.
Mother has the discretion to do anything.
My lords, but I have to be informed. Overnight, I cannot be evicted.
Mother is not evicting you. So you are staying in a portion of the property.
Yes, my
You are
lords.
disturbing the
My lords, I have not disturbed, and the first floor is always locked and keyed. I cannot enter the premises without her allowing me. And the entrance is also separate.
mother wants, she can evict you from the balance portion of the house also.
My lords,
Please stay. Why are you quarreling with your mother?
my lords, I have had no fights, my lords.
What are you doing?
My lords, I am peacefully residing in the property.
What are you doing? I'm asking you.
My lords, the only thing,
For earning.
my lords, I'm not aware of, I have not received instructions as to what he does, what he does professionally, but he's not earning as much as it has been stated. My lords, I have instructions that he wants peaceful settlement to this. What instructions I have received?
Settlement can be made.
My lords, as far as I know, the last occasion, the mother had called the son for talks. She had asked for his personal IDs signed without giving any instructions or any evidence for what she requires. From outside, he's got to know that she wants to give it for development. She also has to give him some time to get to look for an alternate accommodation, my lord.
That's the dispute. So how much time you want to look for an alternative accommodation?
My lord,
This instructions come. Please allow you. After all, he's.
My lord, overnight I cannot arrange.
Wants to vacate. Give me some time. Yes, how much time you want?
My lord, I'll come back taking Yes, my lord, I'll come back taking instructions.
Some time.
Yes, my lord.
Peacefully vacate. Yes.
I have no problems otherwise, and all these complaints about assaults are absolutely false averments, my lord.
The medical report.
Sir, after all, he is your son. So
And I've been residing there for all these years, 52 years, my lord.
yes, I'm not saying son, daughter, both. So
that is
you
why I
also
said,
need
my
their
lord, I
assistance.
don't want to evict.
Please keep all this mind. So he wants some time to vacate. I'm keeping it tomorrow. If you can get instructions, how much time you can communicate to your learned friend so that he can also take instructions and come back.
Sure.
Something more, you are saying something. Some say that can be solved. The You have given this,
Yes.
take it back, please try to solve this.
My client wants to. My lord,
She also wants to,
My
then there will be
I
no.
want to. I have
Yes, she also wants to
actually
settle.
no fights or
She also wants to settle, you also
allegations
want
I've
to settle.
stated.
Both of you settle, it's a dispute between the mother, son and the daughter. So
my lord,
all of you can sit together and
all that the mother wants to survive in life because she do not have now nothing to my lord, have
All right.
food also. So
see
that's
that
why
this
she
dispute
is
is
trying
settled.
to.
Yes, call the next matter. Yes.
Well, a petitioner was driving a bike. Petitioner was driving a bike along with two pillions, my lord. His grandmother and his brother, elder brother, my lord. Crushed after Barakpur, in between Noihati and Barakpur. Elder brother, this happens on 4th, my lord. 4th of this month, my lord. Now, my lord, after this crash, my lord, his elder brother crashed with a Tata. He was actually crashed by a Tata Ace or Tata Chota Hathi kind of a vehicle. Elder brother died out of the injuries on 4th, my lord. From 2nd to 4th, my lord, when this crash happens, my lord, civic volunteers were there. They helped. They went to Noihati, first Noihati Medical Hospital. Then from Noihati, they were referred to AIMS, Koldani. From Koldani, they were referred to Medical College, Calcutta. From Medical College,
the dispute now.
My lord, now the dispute is, my lord, despite repeated, my lord, request to the police, they are not, my lord, giving the CCTV footage, or my lord, they are doing nothing, sitting tight. My lord, without CCTV footage, I don't get the number of the vehicle, my lord, everything. My lord, they are, my lord, they
You have lodged a complaint.
yes, my lord.
Where is the
Ultimately,
complaint?
my lord, complaint is in page, my lord. Only comes to page, my lord, 23, my lord. Ultimately, the FIR was taken after my brother died.
So now the FIR has been registered.
Yes, my lord, after 2 days, my lord. My bike is now in from the day 2nd was with the police. Nothing, my lord. My relatives, I was in hospital. My grandmother was in hospital. My brother was in hospital. My relatives went, refused repeatedly. Ultimately, my lord, these
persons riding on a
my lord,
two-wheeler.
my lord, kindly appreciates, my lord, in the early morning, my lord, my grandmother fell in the ground, my lord, fainted. I was taking her to the Noihati hospital. Sandwiched between
Get motor accident claim compensation.
my lord, that I will, my lord, my lord. There is a judgment of Supreme Court, my lord. But at least they give us the.
My lord, I appear for the state, my lord. Report has been sent by Shivdashpur police station. May I hand up, my lord?
CCTV footages, what do you say with regard to the CCTV footages?
My lord, they have
not providing the CCTV footages.
My lord, a requisition was sent, my lord. Lordship will look at
Requisition was sent to whom?
to the OC Kampa Traffic Guard, Barakpur Police Commissionerate.
Because your report says an unknown four-wheeler.
Yes.
Why unknown? You have the documents. Don't you have the CCTV footages in that locality?
My lord, kindly comes to page 28.
We have, well, under 180 BNSS, we have registered a complaint, my lord.
Complaint you have registered as an FIR. Do you have the CCTV footages? Do you have the CCTV installed in any place within that location where that accident took place? I think specifically the place has been mentioned where.
My lord, it's my lord, paragraph 3, my lord, page, my lord.
Paragraph.
Page, my lord, 3, my lord. It's
they were referred to. No, where is their exact location?
My lord, I have given, my lord, paragraph 3, when the petitioner's two-wheeler reached near Duagachi Indian gas go-down point, a Tata Chota Hathi crashed into your petitioner. My lord, this is the point. And subsequently, it was registered in FIR also.
CCTV camera installed.
My lord, I have given.
Please file a report with regard to that.
My lord, to page 20. My lord, kindly comes to page 28. Kindly, once.
28, yes.
28. My lord, kindly sees with geotag I have provided. My lord, this is the house just at the point of accident. My lord, they have a CCTV. My lord. Kindly comes.
Where?
This is, my lord, kindly sees.
Near that area from
There
where
are restaurants, bars, my lord.
where we have asked for CCTV footages, my lord, and we have not received. We have stated in the report We have sent the communication to the.
You have not received.
Yes, my lord. They
You
could-
have sent a requisition from whom?
We could not provide, they have said that they could not provide the footage cover of the whole
Who
incident.
could not provide?
My lord, it's,
To whom you have requisitioned?
my lord.
And who are not providing? Can you not take steps against them? Can you not take steps against them? If someone does not provide the CCTV footages, can you not take steps under the law? Merely saying we have sent requisition, they are not replying. And he has given an exact location.
My lord, I have given, my lord, with geotag, my lord. The latitude, longitude is, my lord, at least in two pictures, my lord. The second picture at page 29 is the Indian gas go down.
The petition
If it is not, I beg to appear.
My lord, I appear for the state, my lord.
You are for the petitioner?
I'm for the state, my lord.
Yes.
Lord, the petitioner is the wife of the respondent number 4. Respondent number 5.
Family dispute, Mr. Das, in a writ petition. All matters family dispute.
But this is under the Domestic Violence Act. She has been prevented from entering her matrimonial home. She went out to buy a bottle of water in the night at 9 p.m. Lord, on 2nd of November. And when she came back, she had just her mobile.
Petitioner is the wife.
Wife of the respondent number 5. 4 is the mother-in-law. 6 is the father-in-law. He is terminally ill. We have no allegation against him. 7 and 8 are the daughter of the sister-in-law and the brother-in-law, her husband. They are also staying in the same premises, and they have connived together. And the allegation, Lord.
You are for the state.
I'm for the state, my lord.
Where is the private respondent?
I have served, Lord.
When have you served? Mentioning which court?
Lord, yesterday we have informed them that they have given us a letter.
Appearing?
Affidavit of service, Lord. All have received. We have also informed them.
So they have
Everyone has received, Lord.
What order can be passed here?
Lord, now she has been prevented.
Applied under this domestic violence.
Yes, Lord. We have applied. Order has been passed.
Yes.
And now a report has been called for. Today was fixed for the.
High Court is the executing court of that.
I am not asking for execution, Lord.
Execute that order in accordance with law.
Lord,
if an order has been passed by a tribunal, execute that order in accordance with law.
Lord, they have filed a criminal revision.
Make the High Court an executing court of an order passed.
Lord, they have filed a criminal revision, Lord. And in that criminal, that is not maintainable, Lord.
That is a different thing.
That is a different altogether.
Person as a litigant has a right to challenge a particular order. So if it is under challenge, so can this order be passed?
Lord, the High Court has a separate jurisdiction, Lord, to protect the liberty and life of the petitioner, Lord, under Article 19(1)(g) and Article 21.
Yes, but if there is a violation of that right by a private party, show me the law. Writ can be issued against a private party. Article 21 Lord, is yes.
Lord, kindly see what
writ cannot be issued against a private party.
Lord, what I have prayed for, kindly
really
see,
praying for a writ against the private party, can it be done?
Lord, what I have prayed for, kindly see, Lord.
Yes.
That on the basis, if your Lordship kindly turns to page 30, Lord.
30.
30, Lord.
Yes.
Before that, kindly see the order at page 32.
Page?
Page 32, Lord.
Yes.
A report has been called for, Lord, and thereafter an order has been passed. Thus, from the report, I am reading, Lord, the second last paragraph.
This order is under challenge in a criminal revision. This order is under challenge in a criminal revision.
And that is not maintainable, Lord.
That I cannot say so. I cannot.
No order has been passed.
That's a different thing altogether. But no order has been passed. You execute that order. Nobody is stopping you from that. So can you come before the writ court and say, yes, please implement when a criminal revision is pending?
No, I have come for police inaction, Lord.
What is the inaction on the part of the
kindly
police?
See, we have asked for.
Yes, an order has been passed.
The police was
that authority approached.
Lord, kindly see that. Kindly see the order, Lord.
Yes.
Thus, from the report of the IO, it is clear that the accused is not stating the truth, that the de facto complainant was not restrained or she was not dispossessed from her matrimonial home. Now, see, Lord, in this scenario, the IO is directed to make necessary arrangements so that the residence of the de facto complainant can be restored at her matrimonial home. and the accused do not dispossess her in future, and further it is directed that IC Bhatpara PS will make necessary arrangements through the IO of this case regarding the protection of de facto complainant at her matrimonial home, so that no kind of torture is inflicted upon her by the accused persons. So all directions has been given, my lord, to the police to make necessary arrangements. Now they say that it has been locked from the outside, my lord.
If an order passed under the Domestic Violence Act is not carried out, what's the remedy provided under that act? What is the remedy provided under that act? Domestic Violence Act আছে। A 226 court in an executing court of a magistrate. This is what you are trying to do. More so when this order is under challenge. দেখি দেখি আস্তে 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 দেখি একটু ইন্ডেক্সটাতে দেখি ইন্ডেক্সটাতে
29 is the provision for appeal, not
29
yes,
দেখি সেকশন 29 টা দেখি
there is a provision for appeal.
29 হ্যাঁ 29 is the provision for appeal.
Yes, ma'am.
No, execution. Order is in your favor. Execution, where is the provision for execution? This protection orders, how it is to be executed. Appeal. Yes, penalty for breach of protection. देखिए देखिए Hello. You have a copy of the act? Please give
Yes,
it to
ma'am.
me.
Section 19 is the order, is a provision for restoration of the
That
matrimony.
order has been passed.
My lord.
That order has been passed directing.
But the police says that there is no order for breaking open the lock, and so they will not break open the lock for giving her access to the home. That is the complaint made before the magistrate, not. And the magistrate again calls for a report, not. The act,
If there is no, if it is under lock and key, if there is no order,
they are
can the
inside.
Can the police break open the padlock?
That is the order, not. Make all necessary.
For that, belief goes, comes and report.
As far as
lock and
DVAC is
key,
concerned, Lord.
Then for breaking open the.
My lord is perfectly right, Lord. But as far as DVAC is concerned, Lord, it is a separate provision is there, Lord. And kindly see
where
that
is the
make all
provision for-
necessary arrangements. And kindly see the judgments of the Supreme Court also, Lord. This is a beneficial legislation, Lord, for protection of women, Lord. And I am on the road, Lord, without any. I just had a mobile and 50 rupees with me in the night. I stayed in the house of the neighbor. My paternal home is at Jalpaiguri. We have stated everything, Lord. All belongings are inside the house, Lord. Even my papers, my money, the passbooks.
31, section 31 is the remedy.
Possibly this is in respect of section 18, Lord, the protection order, Lord.
Yes, protection of your possession. Protection of your possession.
Protection is section 18, Lord.
Protection of your possession.
Lord, may I come back tomorrow, Lord?
Regular thing.
Lord, may I come back tomorrow, Lord? There is some urgency, Lord. I'll be placing before your Lordship. Your Lordship has heard it, Lord. Just, and I'll be inform them also again.
Non-appeal.
Says, my lord, on previous occasion, my lord, a team of Bhatpara police station went to the matrimonial home and only to find that the entire house is under lock and key and there is no access to enter into the house. Several calls were made.
Mr. Das, it's better you approach that concerned magistrate saying this fact
And
get
we
an order
have,
for breaking open the
my lord,
padlock. That's
we have,
better. Otherwise,
Lord, we have already filed that application.
my lord, we have,
And now the
first get it hard. If it is not hard, you know,
my lord, we have already,
steps are to be taken. Get it hard. Because if it's under the lock and key, police cannot break open without an order.
and my lord,
That's the report now.
and we have already informed the learned magistrate by my lord report, my lord.
Just file a report, he says, stating that
no,
it's under-
today was for date fixed for filing
No.
report. No report has been filed.
On
now he
my lord,
now he's
on
saying if it's a you know the best, you are the best person to know whether it's under lock and key or not. If it is under lock and key, police cannot break open the padlock without a specific order passed by a court of law.
But the order speaks not that they shall make all necessary arrangements for breaking up.
Mr. Das, I am asking you, that's the decree for eviction. That is the order passed. So if at the time of execution, can the police break open the padlock?
No, Lord. Obviously, Lord, in the initial stage, there is no order, Lord.
That is, here is also an order. If they find, go and find, there is a padlock. Unless an order is passed for breaking up the padlock, they cannot do that. It's better, I think, you approach the SEJ for necessary orders. I record his submission that it's under lock and key.
and we have already informed.
Unless that order is passed, here it cannot be passed. Because here, even if I accept your submission, only the police can be directed to comply with that. And that will be their report, it's under lock and key. Here, it cannot be directed to break open that. But that will be beyond the extending the order of the SEJ.
And not only that, we have already informed this fact to the learned SEJM on 10th November, my lord.
10th November, they have informed. Maybe the report they have forwarded to the court.
Lord, may I take instruction? I'm coming back.
I think that's tomorrow.
Tomorrow or day after tomorrow.
Day after possible tomorrow if you want, or next week. Any day.
No, not tomorrow.
Next week, my lord, will be better. Next week, Monday, my lord.
You have no difficulty. You have instructions.
My lord, then my report may kindly be kept to the record.
After
Letter of the advocate so that I can communicate him.
লেটারটা দিয়ে দিন।
I'm extremely sorry. But the only difficulty is these speakers who come, so they have a scheduled date only Friday, because we have to take that date according, because they are not
Only Friday.
I will come back on Friday with an affidavit with proper instruction that when these speakers, because 7th, if I get
That is why I told you if I was passing in the order, it will be a difficulty.
I understand.
That is the reason at times.
Because they are always involved in different places. All spiritual leaders.
You will be filing the affidavit
on Friday, and your lordship can pass that order.
Friday, then I keeping it on Monday. The Mr. Ahmed, only do one thing. If you know the date, exact date when
So I can inform
it's communicated, because they have also to take instructions and they will come and
Yes,
say
sir.
some other examination on that date.
I have number of Mrs. Sinha. I will take the number of my friend.
You want to please communicate to them what is the date you are proposing to.
So grateful. Lord. তোমার নাম্বারটা
Another 22.
21 কি হলো?
22 ওইটা ভুল করেছে।
Well, it came due to my determination in other court matter. 21.
There is a mistake.
Yes, ma'am.
Tomorrow, yes.
মানে স্যার আমার আজকে
Who is appearing? Where is Mr. Oh, you are appearing. Yes.
Lordship. Lordship, may I, at the outset, may I submit, Lordship? I have got the report on the yesterday, Lordship. The report is with me, but the affidavit has not been done, Lordship, as I have received the report on yesterday only.
All right. So when can you file the report, the affidavit?
Lordship, at least 10 days time, Lordship. 10 days time,
Why
Lordship.
10 days time? You have the
Lordship,
information.
SIR is
Drafting
going on
an
that
affidavit. Why 10 days?
7 days at
That's
least.
prolonging the litigation.
Lordship, actually the SIR is going on and all the officers are very much.
After 10 days, we'll be very busy.
Lordship,
10
1
days
week.
will be taking us closer to 4th of December. Collections will be very busy. Do it fast.
1 week, Lordship, 1 week at least.
The learned Yes.
Okay, this is regarding the allotment of land, lordship. Last occasion, your lordship was pleased to pass a direction, lordship, to file a report in the form of affidavit, lordship. State of the business.
Yes.
My lord, Mr. Vimor Shai, AGP is appearing.
Yes, yes. Yes. Yes.
I am a, this is the matter of in the year of 2000, my lord. I am right now. I am not getting the file. In the meantime, file are shifted from writer's into Navanno. That's why I am seeking time to file the report in form of affidavit. 4 weeks time, my
4 weeks.
4 weeks.
my lord.
Christmas will come, Lord.
My lord, to search, I have to create a search committee to search the file. That is the procedure in the government office, my lord.
What is the procedure in the government office?
I have to create a search committee as per the instruction I have received from the ADM LR. And they will search the file, my lord.
How much time it takes to constitute a search committee?
No. It will be in this week, it will constituted, my lord, but I am seeking 4 weeks time, maximum time, my lord.
Sir,
It is up to you. You are giving me my liberty for 3 weeks or 4 weeks, my lord.
Please, I do not understand in terms of weeks. Please tell in terms of days. Don't tell me in terms of weeks.
My lord.
Yes.
My lord, please give me 20 to 21 days.
The time to file. Yes, next. Is this better on December?
My lord.
Yes.
999 year registered lease held by me. They say they had terminated, but given me.
One is afraid of you, Mr. Banerjee.
But I am ready to come in a different avatar. I mean, I will put my head down. I won't say anything if that reduces the scare element. Well, because Mr. Mahato took an adjournment for a day, resisted an interim order saying that I'll bring the record. All they need to show is they have given us a notice to remedy the breach for 6 months, as is envisaged
Where
under
is
the
Mr.
list.
Mahato? Where is Mr. Prashanto Bihari Mahato?
In the meantime, if they deal with the property, I am nowhere. Or if they take coercive steps. Because today this is the third day now. First day he sought an adjournment. Second day on his prayer, again matter was adjourned, kept today. Today the matter came down in the list. Once again, if adjourned today, my lord, it will go further down in the list. Please see, my lord, the orders dated 14th of November and 10th of November and 14th of November. My lord had pointed out. I never want anything ex parte, but if they force me, my lord, I'll have to press for an ex parte prayer.
They're forcing you to take an ex parte order. Yes. Can you call Mr. Lolit Mohan Mahato? Please inform Mr. Lolit Mohan Mahato. Passover, short passover. Yes, next.
File number 25.
Yes.
My lord, this is the report, my lord, in the form of an affidavit.
Report in the form of an affidavit. What is the dispute?
30. I wish to appear for the private respondent number 39.
My lord, kindly, my lord, turns to my lord, page 12.
Please give me a minute.
My lord.
Respondent 6. Respondent.
Yes, page.
Page 12, my lord.
Yes.
It is the Bata Dag, my lord, 531 by 823.
Yes.
Rasta Jomi. And my lord, the erstwhile owner from whom they have purchased the land, they were considered as Beaini Dong. All of them, my lord. My lord, actually, 50 decimals of land were there. 0.06 decimal, my lord, it is recorded as Bata Jomi, my lord, 531 by 823. So remaining, my lord, 49.94 decimal. Therefore, my lord, 34 decimal is acquired. It is acquired, my lord. (531 by 823). If your lordship, my lord, turns to the next page, that is R4.
By 823. Have you given a copy of the report to?
My lord, I'll hand it over. Any, Dada.
Ghosh, oh, you have not given it beforehand.
No, just now, my lord.
It has to go through this.
My lord. No, it is very clear, my lord, from the.
And so,
Maybe it may be clear to you. You have drafted. You have got the documents. He is getting it just now. Mr. Ghosh, please look at the report, only page 11, because you have the copy of the last order passed by me.
I know.
So there was a dispute. According to you, this LR plot number was recorded in the name of the individual rats. So Bata plot number 823. So now please kindly come to the report at page 11. Is the record of rights.
Page 11.
Yes. Now here it's recorded in the name of the development roads.
My lord. It is acquired, my lord.
It's an yes, because it's the state of West Bengal and development roads department, and please kindly turn over to the next page 12.
Yes.
531 by 823 is that plot, Bata plot. Now it's the Rasta Jomi, and the remarks is Beaini Dokol. So you are illegally possessing those properties.
So far,
That's this recording.
so far I am concerned, Lord, I have been told, Lord, that it is fact that out of 51 decimals,
50 decimal.
50 decimals, Lord, 28 decimals were acquired under a particular proceeding, acquisition proceeding.
No, 34 decimal has been acquired.
Lord, that is not correct. Lord, they have not produced any document.
Only one thing. What is the plot in question?
531.
531.
Yes.
531 comprises
50 decimals total.
Where is that? Where is that record of rights? Showing that 531.
My lord.
Yes, 531 is 50 decimals.
Yes. My lord.
That is page 8.
8.
So this was recorded.
Page 10 also.
If your lordship, my lord, kindly turns to page 10, my lord, of my.
So now 531 was originally 50 decimals.
My lord.
Now
34 decimal has been acquired. And thereafter, my lord, kindly see, my lord, page 10.
Lord, that is the only question.
30.
Page 10, 34 decimal acquired. Now, if your lordship, my lord, kindly turns to page 10, my lord, at the right side, last column. Page 10.
Yes.
My lord, kindly see.
531 is 50 decimals.
My lord. And page 10, my lord, it shows that 22, my lord, which is tampering. 22 decimal, my lord, where it is inscribed 22, it is tampering. Everything has been inscribed in, my lord, in a printed form. But only this is one, my lord. 16 has been converted in 22. So it is tampering, my lord. It is reflected.
How do you say it's tampering?
My lord, my lord, I am showing your lordship, my lord. It is.
How this correction of record of rights is made?
My lord, it is ongoing.
How many colors are there for correction?
My lord, it is ongoing, my lord. My lord, it is apparent, my lord. It is very much apparent, my lord. In the.
Say by this, there are different colors. for making these corrections in the
My
record of
lord,
right.
my lord, that is
There is
the,
a procedure in the management.
my lord, but
in the
it is,
manual.
but my lord, it is, my lord,
Corrections is done in this fashion.
no, my lord, it is, my lord, I am showing, my lord, your lordship, my lord, what is the procedure, my lord,
You
for
made out
correction?
a case of tampering.
My lord.
Who has tampered? It's your officers who have tampered.
My lord,
Because the
maybe,
records
my
are
lord,
in your custody.
my lord, may I,
If you say that it's tampered, it's your officers who have tampered.
my lord, it is,
Records lying in your custody.
my lord, because it is a long pending thing, my lord, it is, my lord, the record shows, my lord, it is in the year 1980 perhaps. So, my lord,
The only thing, if they can show any document that 34 decimals have been acquired, Lord,
Now,
nothing, I have nothing.
originally there is no dispute 531, it's what 50 decimals.
50 decimal.
There is no dispute
My
with
lord.
regard to that. Now,
0.06.
if you come to now the dispute is with regard to page 12, plot number 531 by 823.
My lord.
So this is the Bata plot.
My lord.
So the numerator is the original plot.
My lord.
Denominator is the plot which has been carved out from 531.
From 531. Not only from
This
531, my lord.
basically plot number 823.
My lord. But
so 823 is 6 decimals.
My lord, 0.06 decimal. My lord.
6 decimals.
6 decimal.
So what are the other components? How that is why I've asked you how this what are the breakups of this plot number 531?
My lord, kindly see, my lord, if your lordship.
It was initially 50.
Initially 50.
531 by 823 is 6. What is the balance? Where is that?
Balance, my lord, is 49.94 decimal.
Where?
From 50, if we deduct, my lord, 0.06 decimal, it comes down, my lord, 49.94 decimal. 34 decimal is, my lord, acquired.
Where is that?
And my lord, and my lord, 15.94 decimal, my lord, this notification is, they are still trying to find out. But since it is a, my lord, matter of a,
So if it is acquired,
my lord,
Then they have no claim.
and my lord,
then
they don't.
It's acquired. Award has been passed. Compensation paid to whom? End of the matter.
My lord, just my learned friend will show something, my lord. But before that, my lord, exactly, that I am going to show. My lord, if your lordship, my lord, kindly turns to page 23.
Yes.
Certified copy is there. Page 23, my lord, it is the order of district land and land reforms officer, my lord. From the measurement of plot area shown in the maps, it is seen that the suit plot is 531 consisted of 48 decimal instead of 50 decimal.
Yes.
50 decimal as record shows. From the document, from no document, it can be ascertained that 28 decimal out of 50 decimal has been acquired.
Then your own statement, there is no document
which
shows it has been
my lord,
acquired.
the Bata plot
In respect of 28 decimal.
in respect of
28 out
28
of
decimal.
50.
Yes.
So nothing. So 28 is unacquired. Yes,
And my
next.
lord, kindly see the Bata plot 538 by 823 was created through plot border system. From the inquiry report as submitted by the BL and LRO, it is seen from the positional aspect of the claimed area that all other acquired land fall under the same alignment. My lord, there is a map, my lord, which has been annexed, sketch map. May I take your lordship, my lord? It is at annexure, my lord, 4, page 41. Page 41, my lord. Page 15, I'm sorry, my lord, page 15, R4 annexure.
So paragraph 7 also, you say that 16 was the area after acquisition, but it was corrected to 22.
My lord, the correction is pending.
Yes. So no, but after correction, it was converted to 22. So this is not a overwriting,
My lord,
tampering.
my lord, kindly see, my lord.
It's your report.
No, my lord.
Yes.
It shows, my lord. May I,
Reforms officer.
if your lordship, my lord, kindly turns to page 24, my lord.
Yes.
Last paragraph 5.
Yes.
In connection with point number 5, as mentioned by the learned advocate, it is stated that without any reference, any correction in record of right should be demarcated as null and void only a pen through over the record cannot justify a proper correction. So on the basis of the pen through, creation by any new record of right cannot be considered as genuine record indeed. From the alignment of LA plan and as well as from the position of all other Bata plots acquired by the PWD roads fall under the same alignment. The undersigned is of opinion.
The plan.
My
Where is
lord,
the acquisition plan?
acquisition plan is, my lord,
But in spite of repeated.
acquisition plan is not there, my lord. But
Produce.
but my
You
lord,
are saying it's acquired.
my lord, kindly my lord turns to page 15.
Well, their
How could you prepare this note? How could you prepare this order? You don't have any document. How
My
do you
lord,
say it's acquired?
on the basis of the field inspection, my lord.
Field inspection acquired means that you are there. So acquisition has to be by a procedure. You don't have any documents, you say. It's
My lord,
acquired.
it is very old record, my lord. So they are trying to still find it out. But my lord, kindly see the other plots are there. If your lordship, my lord, kindly turns to page 15.
1-5.
1-5. Annexure R4, my lord. 1, 2, 3, 4.
Yes.
The my lord, line the alignment, my lord.
So this is the Moja map.
Moja map, my lord. I'm showing it, my lord, because it is earmarked, my lord. May I show it to your lordship, my lord? So this is the plot, which is the total Bata land, Rasta Jomi, which has been demarcated. So, my lord, all the other land from which this Bata land has been plotted out, my lord, it is the same alignment. So one plot, my lord, it is very, my lord, justifiable ground, my lord, that one plot of land amongst them, it is not possible that it was not acquired, and other plot has been acquired.
Maybe.
And moreover, my lord, it is a purely dispute.
It was in one proceeding.
My lord.
So if you get the records of that proceedings, you will
My lord,
get the entirety.
my lord, this is a very old record, my lord. Kindly see. That is a very difficult, my lord, for the officers concerned, my lord. And my lord, this is a purely disputed question of fact, my lord. So read code, my lord, cannot enter into it. And the cause of action, my lord, is beyond the scope of the writ jurisdiction, my lord. Kindly see, my lord, it is a matter of a 1980. So after a prolonged period, my lord, it is too difficult for the officers concerned, my lord, to.
Mr. Ghosh, some more time has to be given.
Well, your lordship, they give it. Kindly see page 20.
Because, my lord.
Page 20 of their annexure. Page
Yes.
20, this is the order sheet. Order sheet.
Yes.
As the matter was scheduled from middle here, lordship kindly see the through LA case number, your lordship will get. I'm reading the entire. As the matter was scheduled today, the petitioner along with his advocate, the assistant.
These decimals has been recorded in favor of PWD rows, and that recording is erroneous.
Yes. And they sought for time to produce appropriate, not done.
Yes, DLRO himself says that recording is erroneous.
My lord, but subsequently, my lord, this order has been passed on the basis of the said record, my lord, because it is not a single day proceedings, my lord. It is a continuous proceeding. My lord, kindly see the next paragraph.
I am telling
the next record.
Position other than LA case, but no supportive document was received.
Yes.
Kindly see
the documents, and it shows that that recording you have said that the recording is erroneous.
My lord, then
come out from that. It's your admission that recording is.
Kindly, my lord, give me few times, my lord.
My lord, give me opportunity to file a affidavit on my part, my lord.
Who are you?
Private respondent.
The transfer is of 16
I have,
decimals.
my lord, the notification as per the, my lord, instruction of my client, my lord.
You have the notification?
No. So I may, my lord.
Bring the notification.
So, my lord, kindly give me, my lord, direction to file the affidavit in opposition.
All right.
And my lord, one thing, my lord, another one thing, my lord, kindly, my lord, come to the my lord, the repetition, my lord. In my lord, this list of dates, my lord, kindly list of
dates.
My lord, kindly.
What is there in the list of dates?
My lord, the list of dates, my lord, from 2011. My lord, all are, my lord, narrated.
Not been settled by Mr. Ghosh.
No, my lord, no. All are narrated in the criminal case. Kindly, my lord, kindly see, my lord, kindly see.
I have seen it.
Technical difficulty.
My lord, points of law also. Warrant of arrest.
Copy paste. Copy paste.
Copy paste.
report in the form of an
হ্যাঁ আমি জানি স্যার নিশ্চয়ই কোনো
Lord, interim order may be extended.
Interim order is till
November.
or till November, till the end of December.
My lord, I am praying 2 more days, my lord, on Monday, my lord.
Then Monday, my lord, you mentioned, my lord, when this will come further down the list, my lord.
Let it,
Last day it was the first or
let
second
it be
motion.
the first item I
And
have,
it
I
became 12.
Motion is, Mr. Banerjee, you have had the chance to move once. You are having the chance to move today also.
Yeah, the chance
So
is there.
others are to be given first chance.
Yeah.
You are getting the next day will be the third chance. First chance will have to be given preference.
at 2 p.m. fixed.
Yes, my
Fix,
lord. 2
why?
PM, we kindly fix it.
Mal-
It's a- it's a single instruction.
This is
Some same heading, the you are directed to file report.
my lord.
To take instructions as to
Instruction.
whether they have served a
Whether the, my lord, the
Notice to
2000
remedy the
notice
breach.
has been served, any breach.
notice to remedy the breach has been given or not.
Mr. Ban
My lord, I am for the petition. I am for the petition, my lord. This is a matter of 2024, my lord, in the
Matter of 2024.
2024, my lord. First time it is appearing, my lord, after mentioning, my lord.
I appear for the
Initially-
state response.
Initially, I served the notice, my lord, all are received. This is a, my lord,
You have
another-
served the notice in 2024.
Yes, yes, that's why I am praying, my lord, kindly direct the, my lord, page 27. Kindly direct the assistant engineer to consider my representation because he, private respondent,
Yes. What have
But
you
I
done?
appear for the state respondents.
Yes,
My
what
lord,
steps have you taken?
my lord, steps with regard to my lord, it is the authority with whom they have approached, and till date I have no instruction with regard to my lord, steps that has been taken. And as my learned senior friend has just pointed out, it has come up suddenly. My lord, I was also taken aback with regard to.
Not suddenly.
No, suddenly I have mentioned.
So it is
No, my lord, it was not.
2024.
No, my lord, I was not put under notice that.
Why are you mentioning without giving the notice?
That's why I
How will they know?
Only I have an instruction of the.
Taking that once you are mentioning, I'm directing this matter. It's expected that you will notify the other side.
I only have an instruction of the police authorities, which is probably of no use.
The petition.
Another thing, my lord, private respondent number, my lord, private respondent number 9 died in the meantime, my lord, but his legal heir are party to this proceeding 10 and 11 only.
No other. So
No other.
legal heirs are already on record.
Yes, 9, 10 and 11, my lord. Rupai Singh died, my lord. 9, Rupai Singh died.
Learned Report of the police.
Police was, they have made police a party in this matter.
Report filed by the
But in this matter, I am for the petition. Petitioner. But the petitioner made application before the authority regarding demolition of structure under section under premises public premises eviction of unauthorized evident occupant act 1971.
of determination.
There are around a lot.
71 Act.
71 act. But this may be group. Oh, at the time when I filed this application, there was no determination. So group 1.
71. For want of determination, let the matter go out of.
28 and I am appearing on 62. This is the affidavit service, my lord. Petitioner is 68 years age old lady, my lord. She had a inherited a plot of land, about 15 decimals of land, my lord. My lord, the respondent authority has approached before the petitioner for construction of a rural hospital under name Shodol Sushastho Kendra Horgram. My lord, the petitioner granted, my lord, gave her land to the concerned BMOH, my lord. My lord, a two-storied building has been constructed. My lord, I have annexed the photographs. My lord, in such two-storied building, my lord, a rural hospital is running, my lord. And I was allowed to stay on the second floor, G+2 building, my lord.
In the hospital, you have been allowed.
My lord, first floor, health center, my lord.
Health center.
Rural hospital, health center.
First floor you are staying.
Second floor, my lord.
Second floor.
G+2, my lord.
They have constructed
They
on
have
your property.
on my property without any acquisition, and now they evict me from such my lord building, and no compensation, my lord, has been provided.
You have been allowed to stay in the second floor.
My lord, I have been allowed to stay, but I recently, well, in 2024, I was thrown out from such portion, and my lord,
Second floor also you have been
yes,
thrown
ma'am.
out.
Yes, ma'am.
Yes, what is your instruction?
Lordship,
Only, my lord.
Lordship, let me take the instruction, Lordship, I have not.
Any reply to the RTI Act?
My lord, reply has been given, my lord, page 31, that no LA or RA case number has been mentioned. That is why no information provided. Thereafter, I have
What is
sent,
the plot of land?
my lord, paragraph 3 of my petition, annexure P1.
Claims to be
Affidavit service I have submitted. Affidavit of service one. Affidavit of service I have.
Civil service filed in court today is taken on. Yes. Petitioner.
I am for the petitioner. Madam.
Yes.
Well, the petitioner has assailed, which is at page 42 of my writ petition, is an order of demolition passed by the assistant engineer
Under section?
under section 10(1), my lord.
10(1).
10(1) of Highways Act. my lord,
1964 Act.
1964.
Yes.
My lord, the proceeding initiated in terms of an order of coordinate bench of this honorable court. Well, the High Court order is at page 25.
Yes. What is the ground of challenge?
Well, the ground of challenge is one of the grounds the Honorable High Court, Honorable Coordinate Bench directed the assistant engineer, directed the BL and LRO to prepare a map and report with regard to encroachment made as per allegation made by the private respondents hearing. Well, a report was and a copy of the same was to be furnished to the petitioner, that is private respondent hearing, and the private respondent over there and petitioner hearing, and also the jurisdictional assistant engineer. Well, the report was furnished, but truncated copy of it was sent. The content of the report clearly shows there was a sketch map, a GP revenue inspector's report, but nothing was furnished. And the proceeding was going on, and thereafter, even from the order impugned, my lord, it will be found that such report was the exception to the report was filed by the petitioners to their learned advocate. Even that was not considered. Nothing has been considered, though they say whatever has been submitted is taken on record. Nothing else. No discussion, nothing.
What is your name?
There are, my lord, 3 petitioners.
Yes.
Pradeep
What is your
Ghosh.
name? What is your name?
Pradeep Ghosh, petitioners, my lord.
Pradeep
Pradeep Ghosh, Rajiv Bishwas, and another one, my lord.
Ghosh,
Apurva Bishwas.
Rajiv Bishwas and Apurva Bishwas.
My lord, 3 petitioners.
3 petitioners.
We were private respondents in the earlier writ petition.
Yes, yes.
All of them were present, my lord, in the hearing. All of them were present.
We were present, but we filed an exception to the report. Duly submitted to them. My lord, the exception I have annexed to the writ petition, which is at page 35. My lord, the physical inspection report is at page 29. My lord is taking up 29 page.
Page 29.
Page 29, my lord. Kindly takes up once. The body of the letter starts with enclosed herewith the physical inspection report submitted by the Revenue Inspector Joyghata GP dated 29 January 2025, which will speak for itself. Look, it is a part of this document which has been served
What is
out.
the document which was supplied to you? Have you annexed that?
This is the document, 29. Only page 29.
Nothing more.
Nothing more, my
No
lord.
annexures were submitted.
No annexures, my lord. And I have pointed that out in my exception.
Where is the original copy of this document at page 29, which was forwarded to? You have the copy of that?
No, my lord. The original I may not have. Petitioner may have. My lord. The petitioner in person may have.
He must have given it to you for making.
The
for
original
filing
I
the
have
petition.
seen, but I have not kept it, my lord, with me. Original I have not kept
From
it.
which you have made a photocopy of this. Please show me that document once.
Well, let me just find out from my.
And where is the, after getting, before the assistant engineer, you have filed a written representation.
Yes, my lord.
What is that?
Page 35, my lord.
35, yes.
After getting the report. Yeah, my lord, I have the original, my lord. I'm sorry, my lord, I have the original of the copy sent to one of the petitioners.
This is the original that was served upon me. The signature is original. My lord, I'm sorry, I did not look at it that I am carrying the original.
Yes. Please kindly come to page 36, paragraph 4 of your reply.
My lord.
What is the basis of your this statement?
Basis, my lord, the actual statement.
Without getting the copy, how do you know that the physical inspection report does not reflect the actual state of encroachment insofar as it regards to the clients and some other parties? You have not got the inspection report, and how can you take this point?
And paragraph 5 similarly. Because of paragraph 5, man. Because of paragraph 5. There are other encroachments that I have instruction, my lord, that there are other encroachments. Those were not taken into account. That is why this statement came, my lord. Paragraph 4 is because of paragraph 5.
Has been issued in reference to documents bearing relevant memo numbers and dates of our copies and contents of such documents. Yes. So your specific case is that no documents have been supplied to you. So you do not have the sketch map. Then how do you know whether it contains the sketch map shows your encroachment or not?
No, my lord. I am saying paragraph 5.
Yes, I am asking you what is the basis
my
of
lord.
your paragraph 4?
Yes.
Statement in paragraph 4.
May I-
Without looking at that, you know that
My lord,
must have seen from somewhere else.
Yes, my lord.
Yes.
Seen but not handed over. That is the thing, my lord.
So
They
you
have seen-
know, yes.
I have seen that there is a sketch map, but it was not handed over. Otherwise, I could not know. But it was not given to
Sketch
us.
map was there, it has been annexed. So you
My lord,
know
even
what
the-
is there, Mr. Pishar.
My lord, the
What is there
content-
in the sketch
but-
map, you are aware.
My lord, unless I have it with me, a copy of it, how can I deal with it, my lord?
From whom you have seen that sketch
My
map?
lord, when it was being
Has it
handed,
disclosed that you have got to see the copy of the.
my lord, I cannot
sketch
name
map.
any officer, my lord. I cannot name any officer, but the thing is, when it was served upon me, I saw there is a sketch map, but said I cannot hand it to you.
These are very easy to be taken, but it's
Well, it
difficult
was
to
not-
substantiate that.
My lord, it was not handed to me. And my lord, not only this, the later part of paragraph 5.
Mr. Mukherjee, you have a copy of the report?
Yes.
Please give it to me. Do you have an extra copy of that report? Yes.
In paragraph 5, the later part, it was written that there are other encroachments. Those were not taken into account while deciding.
Another thing, let me see.
Well,
whether
that
it
has
is
been
done.
taken care of even the petitioners. I was the petitioner earlier, my lord. I have been directed to remove my encroachment. I have considered to that.
You have been.
Yes, yes.
You have removed.
No, I have. Yes, I have. I said no problem. Remove me.
No, have you removed? I am asking you.
But I have to take instruction. Page 43. We have no objection that we said.
Sir, Mukherjee, where is that report? Sketch map. Report is. Want to see the sketch map? Please show me the sketch map.
Well, I have never stated that. I have not seen that. I have stated it was not made over to us, my lord. I have seen that when no, my lord,
Need to take this, please.
no, my lord, enclosure was not given to us. That is my instruction, my lord.
It's very easy to take these points, but replies are also to be carefully drafted.
Yes, my lord. That is why it was not made over.
On the challenge the 22nd July order. After that, my lord, it proceeded to the my lord subdivisional officer under 10.3. And that hearing has been concluded. No.
10.2 is going on.
And that has been concluded yesterday.
No order is.
That has been, hearing has been concluded. That my instruction yesterday that was fixed for hearing, and hearing has been concluded. And and they were also present, my lord, before the subdivisional officer study.
Rajiv Bishwas. Rajiv Bishwas is B and B1. B and B1. And Pradeep Ghosh is D and D1.
Pradeep Ghosh,
And
D and D1.
yes, and what is the other client? Rajiv Bishwas, Apurva
Vishwas.
C and C1.
Rajiv Bishwas, Apurva Bishwas.
And Pradeep
What is
Ghosh.
the name of your client?
Sanjay Bishwas.
Sanjay Bishwas A and A1. So your only allegation is that you do not have a copy of the sketch map.
The report and anything that we have submitted, it was not.
All right, I am
Answer that.
directing.
And
I'm
my lord,
directing Mr. Mukherjee to please supply a copy, and I'm directing the assistant engineer to give an opportunity of hearing within a week.
But after this order of assistant engineer, this was referred to the subdivisional officer for the next stage, and subdivisional officer.
You have not removed. All right.
And
so do produce all the
he
matters at 10-3 stage.
He participated before the SDO,
10-3 is over.
and that is yes.
No, my lord.
Yesterday that has been concluded.
Subject to correction, my lord, 10-2 is going on. 10-2 is going on.
10-2, you have not removed.
No, my lord.
So if you have not removed, so 10-3, I'm directing Mr. Mukherjee to serve you a copy.
Or kindly have a look to this.
So it is to be decided upon evidence.
My
You
lord,
will be given a chance to file a reply to that.
Kindly
my
have a
lord,
look.
subject to correction, my lord. 10-1, this report was prepared even prior to 10-1. After 10-1 was done,
Has to be because 10-1 starts with the expression if any person is found to have encroached.
my lord.
So there has to be some evidence for the assistant engineer to come to a finding that there has been an encroachment. That's the demarcation map plan which has been made, and according to you, you are not given any opportunity. All right. If that is only a notice of removal. So I record that it will not be removed. It will be referred to the under 10-3 stage. 10-3, it's obligatory to decide upon evidence.
But kindly have a look.
So this will be considered. Your reply will be considered. 10-3 will be decided.
That means my opportunity at 10-1 and 10-2 stage goes.
Show me that you have an opportunity under 10-1. Show me from the provisions of the statute. Show me. Show me from the provisions of the statute.
Not
10-1, sir.
10-1, my lord.
10-1.
But the Honorable High Court directed that an opportunity of hearing was to be granted to both the parties, my lord. Besides 10-1, the Honorable High Court's order is also there as a guiding principle, my lord. That is why, subject to correction, I am submitting, my lord.
All right.
10-3 is over.
Staying this, not to give any effect, I'm directing the assistant engineer to give you a hearing.
But 10-3 is over, my lord. 10-3 is over. I have handed over a copy. Kindly takes it up. Kindly takes it up. I have handed over just a copy.
10-2 is going on.
10-2 means, well, once it's referred to the executive magistrate, 10-2 is over. Now 10-3, it says that he has to take a hearing. That's the executive magistrate, is the SDO. SDO concluded his hearing yesterday.
10-3, yes.
Yes.
Action under 10-3.
And that is
the 10-3 stage, Mr. Vishwas.
Yesterday, my lord, that was concluded. They were present.
Concluded?
No, my lord. One thing, if the report, Mr. Mukherjee, can you show that the report was served upon them?
Only when they are in the.
So, Mr. Vishwas, none of your clients received.
No, my lord, they received this one. That, as I have shown, my lord, this is marked as Apurva Vishwas.
All of them.
One has received. I am not disputing regarding them whether they have received this one or not.
No, not this one. The sketch map.
Sketch map they have
yes,
received. That is my instruction, my lord.
But there is a reference of enclosure.
Can you show that all you have served the copy of the map to the parties?
Enclosure is there.
Where is the order of the coordinate bench?
My lord, page 25, my lord. Now, page 26, second paragraph onwards, the operating directions are.
Mr. Mukherjee, unless you can prove that this report was served, first is there are two things. There's a direction to serve upon them by the coordinate bench one. Two is if you rely upon any materials, it's your duty to supply copies to the other side. Otherwise, it's violation of the principles of natural justice. So, because 10(1) statute do not contemplate any hearing.
Any notice.
So, hearing is contemplated only on the adjudication is only under 10(3). 10(1) is a prima facie satisfaction on the basis of some materials. But now here, there is a direction passed directing an opportunity at the stage of assistant engineer under 10(1).
And they appeared.
So appeared, but without any.
And that's their claim. But page 29 shows, my lord, enclosure. Page 29.
Enclosure.
That shows enclosure.
He says first copy.
That I understand.
Then
can there be any proof? Can there be any proof? The first page was served, if I say, and the rest portions were not. I think there is no mechanism to show that this was served.
Page 43. In this regard, petitioner and private respondent both argue and submit the supporting papers which are kept with the option. On page 43.
Page 43 of the writ petition.
Yes.
Page 43, yes.
The second paragraph. In this regard, petitioner and private respondent both argue and submit their supporting papers which are kept with the bench.
I have not denied that. I have stated that.
Mr. Mukherjee, he was given an opportunity of hearing. He is not disputing that. But according to him, that is not an effective opportunity because he was not having a copy of the demarcation plan. And you are directed to give him a copy of the report. He says first page he has got. Filing of a writ petition without annexures. Now you are coming with a supplementary affidavit. At times you come through mistake. Annexures have not been. And in the service copy also, Mr. Mukherjee, you know, sometimes you come up and say only the copy of the writ petition has been given, not annexures. That is the plea which he is taking now. How soon can you complete this? It only requires a hearing. Everything is done. 2 weeks. Why 3 weeks? Give him, finish it off. Nodia, you will not go to Nodia. You will only communicate. Let him fix a hearing date. You give a copy just here and now. Mr. Vishwas, one copy will be given. All the writ petitioners are.
Yes, I'll receive copy.
You make copies, give it to all of them.
Yes, madam. I'll do that.
Ashwin. The seen. Please give these documents. I've folded this for you. Please check. Please go through this, give all these copies.
My lord, he has,
I've seen these are the only documents.
my lord, he has given me the
Mr. Mukherjee
entire
already
report.
handed over the entire bunch.
He has given me the entire bunch.
Entire bunch.
Already handed over.
I'll make a copy and send it over to him, my lord, once again.
The
Item number 37, the authority fixed tomorrow at 1 p.m. for demolition of my building.
for demolition,
Yes. I have a case. In the
you have a case that is listed.
no, but
That I
yes,
know.
but
Not on merits. Who is for the state?
the state, nobody was,
Appearing for the state.
I inquired from the GP office, that nobody has been allotted from in this brief. Kindly,
kindly fix tomorrow at any time.
রাখুনি নিশ্চিত
এখনই হয়ে যাবে
নিশ্চিত
তাহলে আসো আর মাইলট বলবে তুমি আসো।
37 টা দেখি।
একটা একটা ব্রিফ দাও না
দিয়েছি এই যে আমারটা না
Yes.
53 page 53 54 55 the record of rights. This is my purchase land. The subject plot
What is the
Thank
issue?
you.
What is the
10-4
given a copy to Mr.
yes
Bhatt?
yes 10-4 order has been passed.
10-4 order has been passed.
Yes why I am not agree kindly comes to the plot number is 491.
Where is that order of 10-4?
page 82 80 and 82 খোলো
The 7 rule till 10 is 82. Civil suit is there, Mr. Ghosh?
Yes no
plenty is returned
Has to be a civil suit considering
Yes,
the
yes.
appearances of the party. There has to be some civil suit.
case is in the suit plot total area is 53 decimals. In a LA proceeding, LA case
And
that
where is the order passed under 10-4?
10-4 is 70 page 79.
এটা হচ্ছে যে 10-3
এটা 10-4. Teaching magistrate.
কোনটা 10-4
No, 79 page 79.
Any private respondent is there? Tomorrow is the date. Where do I get that?
This is the notice.
নোটিশটা একটু দেন না যাচ্ছে
Tomorrow when?
1
at 1 p.m.
1 p.m. Mr. Banerjee, Mr. Bandyopadhyay, please see, ask them, I'm keeping it tomorrow. Ask them not to demolish, I'm not passing any formal order. Any order is necessary, Mr. Bandyopadhyay, or you will communicate.
lordship pass an order.
Order proceedings are complete, my lord.
I will take it up tomorrow, sir.
অর্ডার পাস করছে আজকে কালকে নেবে
Uh,
করতে বাদ করছেন
mm,
in this matter I'm appearing with Mr. Sinha.
Mr. Ghosh
At 1 p.m.
1 p.m. maybe
I shall communicate.
know what
I shall
will happen.
communicate, my lord.
Mr. Dolopati will take some resolution.
Well, he is the secretary of the bar, and otherwise, my lord, I shall
That
be
is why
in
he will
difficulty.
take some resolution and say
Yes, my lord, I will be in difficulty.
everything is in his hand.
Thank you.
Yes, sir.